Good morning, everyone. Dear President of the LIBE Commission, representatives of the EU institutions, esteemed colleagues, representatives of NGOs, participants in presence and online. I'm Mario Savino from the University of Tuscia in Italy. I welcome all of you to this roundtable on the EU Pact on Migration and Asylum and its implementation. As one of the scientific coordinators of the event, I will briefly introduce. To begin with, we are very glad and thankful for this opportunity to be here in Brussels at the European Parliament with good weather. This is indeed a great opportunity for us to engage with members of the Parliament, high officials of the Commission and other academic colleagues in a conversation on the proposals related to the Pact. Now, first of all, let me acknowledge that this roundtable has been organized by many actors. The Jean Monnet Center of Excellence of the University of Tuscia, which I have the privilege to coordinate, Tilburg University, Radboud University with its Network for Inclusion and the Centrum for Migrationsrecht. I hope I pronounced it correctly. The Common European Visa for Humanitarian Project of the University of Tuscia. And I would try to briefly introduce the event by saying a few words about the stage of negotiation and the purpose of this roundtable. Now, we all know that after a failed attempt in the past legislature, in September 2020, the Commission proposed a new comprehensive reform known as European Pact on Migration and Asylum. We all know that the negotiation process is now reaching a crucial point. According to the roadmap agreed by legislative institutions, all texts must be adopted by February 2024. And we are all aware that the European Parliament adopted on 28 March 2023 its position on the main building blocks of the reform, namely the Asylum and Migration Management Regulation and the Asylum Procedures Regulation. Now, we also know that the Council has not yet reached a political agreement. The Swedish presidency is determined to approve a general approach within a few days at the next Home Affairs Council, so as to obtain a mandate to negotiate with the European Parliament. And if the goal is achieved, trilogues on these two texts would start before the summer. The purpose of this roundtable is twofold. First, we want to focus on the main issues that are still on the floor, that still divide the position of member states and Council on one end and the European Parliament on the other end. The second is to take a step forward and to project us towards the implementation stage, so as to address the question that would arise if the Pact proposals are actually adopted. The questions are, how feasible is the implementation of the Pact? How prepared are national administrative systems? And how evenly or unevenly distributed are the costs of adaptation and implementation between southern, northern, and eastern member states? Before leaving the floor to Professor Lopez Aguilar, let me remind you that this event will be recorded. There are a few basic rules to follow. We have 4 panels, each one lasting 45 minutes, short span of time. So therefore, please, speakers, you're invited to present your views in no more than 10 minutes. Moderators are invited to be strict in managing the scarce resource of time. Participants can ask questions after the presentation of the speakers, but given the tight time frame, we will be able to collect no more than 3 to 4 questions per panel. Online participants are kindly invited to put forward their questions in the chat, from which the moderator will select the question to pose to the speakers. Now it's time to leave the floor to Professor López Aguilar, President of the LIBE Committee, for his introductory remark. Professor Aguilar, my warmest thanks for your participation. You have 5 minutes for your introductory remarks, please.
It is me to thank you, Professor Savino, and all of your colleagues, all the people gathering in this discussion. You're honoring the European Parliament by being here, by discussing matters of our competence, of our work, and by bringing your thoughts to the relevance of the issues which are at stake. So it's me to thank you, Professor Savino, and I only hope that I can be of some use by using these 5 minutes, because it'll take to make the long story short. Actually, a real long story, real short, and I'm going to try. Once upon a time, migration and asylum issues were the sole competence of national member states. It was some time ago. The Lisbon Treaty entered into force, along with the Charter of Fundamental Rights, stating it clear that migration and asylum issues, both when it comes to lawmaking and when it comes to decision-making first, have a European dimension, and they take a European response. They take European legislation, which is to be binding for the member states. That wouldn't have happened if all of the member states would have not agreed. For the Lisbon Treaty to finally make it into force and the Charter finally make it into force, it took the signature of all member states. Otherwise, it wouldn't have happened. But incredibly enough, almost 14 years after, the member states are showing that they actually weren't aware of what they were actually doing. They were not fully aware of the step they were actually making by finally having it clear that both migration and asylum issues are global issues that take global answers, and we must act at the scale of the regional integration of the European Union, which is meant to be globally relevant. Second idea, migration and asylum policy making and lawmaking are enshrined in a specific chapter of the Treaty of Functioning of the European Union, which is enlightened by other principles and other rights enshrined in the Charter, namely Article 18 of the Charter of Fundamental Rights. That chapter is Title 5 of the Treaty of Functioning of the European Union, Article 69 to 89 altogether. And the point is that there are two basic principles which are enshrined in this charter, the principles of shared responsibility and solidarity. So there must be a balance between responsibility and solidarity, and we have tried hard to secure that balance. Actually, we have delivered. Throughout these years, we have put in place a migration package consisting of no less than 8 pieces of legislation, 8 legislative acts, and an asylum package consisting of nothing less than 9 pieces of legislation. So there is such thing as EU migration laws and EU asylum laws, of course, enlightened by international law, particularly in the asylum field. And yet, throughout the years, we have seen time and again 2 major flaws in the way this system, this so-called common European asylum system, has been worked out. 2 major flaws. To put it short, number 1 flaw, lack of solidarity. And solidarity is there, enshrined in Article 80 of the Treaty of Functioning of the European Union. And we have seen particularly those member states in the front line leaning to the Mediterranean, and as it is the case of Spain, not only to the Mediterranean, but also to the Atlantic through the Canary Islands, which happens to be the most perilous and deadly route to the European Union when it comes to irregular migration, complaining time and again of lack of solidarity from the others, turning a blind eye on their dire situations to face the challenge. And the second flaw is an increasing number of cases of member states simply ignoring or violating their obligations to EU law. Increasingly, even disregarding not only infringement procedures, but even rulings by the European Court of Justice. That is why we insisted in this mandate of the European Parliament, 2019-2014, when investing Ursula von der Leyen as President of the Commission, that we have to make it right. We have to strike a new balance and make it right. So she committed herself to come with a new package, a so-called Migration and Asylum Pact. And she did, with some delay because of the pandemic, but in 2020, finally the Commission presented 5 regulations, which is somewhat of a political choice, because regulations are meant to be particularly binding for member states with direct efficacy and effectiveness upon national law, and to create rights which are directly arguable by all of the not only EU citizens, but even third country citizens, which are under EU law, to seek for redress, judicial redress, if needed, all the way to the European Court of Justice. Okay, 5 regulations. Ever since, we have been working real hard in this new Migration and Asylum Pact to make it right, to finally make it right. You know how it's like. I don't need to explain you the package. It's 5 regulations. It's the most, the heaviest piece in this package is the so-called Regulation on Asylum and Migration Management, the so-called RAM in the acronym, which is solidarity in the making, then accompanied by the crisis regulation, of which I am the rapporteur, which is binding solidarity in the making when it comes to emergency, when it comes to a crisis situation, particularly after search and rescue operations, which is often the case in Italy. It takes binding relocation programs. Then there are 3 other pieces of legislation. One is screening, which is insisting on the securing of the borders, external borders of the European Union. Eurodac, which is biometric identification of everyone entering the territory of the European Union. And then finally, a new recast version of the asylum procedures guarantees, which are now a brand new regulation. They are intertwined. So the first political choice we made in the European Parliament was package approach. We are not to accept any slicing or cutting the package into pieces. They have to mean together, all together. They have to make sense all together. They are intertwined. They have to make up a system. That was the first choice. The second choice is to compel the Council, because the European legislative procedure, I'm sure you know, is highly sophisticated. First, we need to come up with a majority within the House. And that takes a real lot, believe me. Maybe you're familiar with the European legislative procedure, the European lawmaking procedure, machinery. But if you're not, just let me summarize, it's highly sophisticated. We have a history of 40 years of directly elected European Parliament. Actually, this is the only democratically elected European institution in the European architecture. And we do make laws. Actually, we happen to be the only democratically elected supranational lawmaking parliament in the world. But never in the history of the European Parliament there has been a political group or political party who has a majority on its own. So it means that the rule here is to negotiate cross-party negotiations round the clock, open-ended. And insofar as the files are intertwined, that took a lot of negotiations. We spent 2 years of hard work negotiating with each other, hand in hand, pluralistic negotiating teams, and finally we made it. We came to, the usual word to describe the outcome is compromising, to compromises that were endorsed by a clear majority of the House, including binding solidarity for good in the crisis regulation, binding relocation programs in the crisis regulation. And then we approached the Council, and we set forth the Council to commit the Council with the so-called roadmap, which makes sure that this time we're going to make it right. We're going to deliver before the end of this mandate. So compelling all the presidencies, all from the French presidency to the Belgian presidency, which is the final one, but particularly through the Spanish presidency, which is starting July the 1st, we have a window of opportunity, having a negotiating mandate with the kick-off trilogue we had with the Swedish presidency, to make it right. So we have a chance. And at the outset, of course, I am not over-optimistic, never have been, particularly in this field. At the outset, I was more pessimistic about the possibilities of actually achieving something. Now I'm growing optimistic. I've been growing throughout the years, optimistic, to see that we have negotiated hard, we have come to compromises, and we have committed the Council. And we see the Spanish presidency much committed to this migration and asylum issue for good reason, for good reason. And the final point I'm making is sure you understand that these issues you are about to discuss, the Migration and Asylum Pact, happen to be extremely divisive across the European Union. They are divisive. Geographically, it's not the same to be Baltic than to be Maltese in this regard. Not the same to be Swedish than to be Spanish in this regard. It is ideologically divisive. For sure, you take it for granted. It's not the same to be reactionary, Europhobe, or anti-European than to be progressive, pro-European. It's politically divisive. It's a fact that at times national elections are fought and at times won on this axis. And won on this axis. We have seen dramatic shift of governments on this axis. The point I'm making is that, yes, we know it's hard, but still, the main point I would like to share with you is the conviction that the only way to have an effective response is to make it European. And to make it European, I mean to make it consistent with EU values and, of course, bound by EU law, for sure. EU law binding. EU law are binding member states. It takes that to be effective. Otherwise, we're doomed to fail. You may argue, no, this is the national competence. Who is the European Union to tell me who am I to allow to enter in my territory? That is old-fashioned rhetoric, for sure. But it's doomed to fail. It's not understanding that migration have always been there. Migration is a fact. Migration will always be there. The only way to handle is to have a European dimension, to act globally and meaningfully. That is the only way we have a chance to be somewhat effective. Otherwise, every member state with its national reactionary stances against a fact is completely doomed to fail. And despite, because I represent, I'm finishing, I represent the European Parliament, the European Council of Justice and Home Affairs, despite I see that doomed to fail rhetoric time and again, ripristinata, time and again back on the stage by the allegation that migration is an evil. And the first choice is that we wish it didn't exist at all. B-plan, given the fact that it seems that it insists to exist, let at least ourselves keep it aside, out of our sight. Let's hire someone else. Let's contract someone else. Let's pay someone else to keep them out of our sight. Doomed to fail. It'll never succeed. That strategy cannot succeed. Then once we accept that some irregularly make it here, let's push them back. Let's bring them back where they belong. Doomed to fail. You need an incredible diplomatic muscle to build the return agreements and to convince third parties, third countries, to have them back. Well, that may be part of the alphabet, but it's not the only letter of the alphabet we must think of. We must also think of being consistent to our values, consistent to EU law, change the look to migration, which is predominantly negative, to a more positive approach, and deal with migration as a fact, and even take some benefits of it. When it comes to economic and social magnitudes, there must to be gained with a change of look to migration. We have a chance. It's not written that we must fail in this regard. And if we fail, that would be a major blow for the whole European Union idea as a whole. Thank you.
Thank you very much, President López Aguilar. Thank you very much for your thoughts. They were a perfect introduction to our works. Now we move to session 1, border management. We have 2 panels, one on border procedures, screenings and returns, and the other on integrated border management and the role of EU agencies. My proposal would be an adjustment of our works because time is running out, and therefore I would suggest to first give the floor to all the speakers of the two panels and then have just one common discussion. Okay, I leave the floor to Emilio De Capitani from the Free Group Executive. He's director of the Free Group.
But in fact, it was only to moderate, so maybe we can go even further and asking Laura Ferrara if she wants to intervene, because after the introduction of Juan Fernando, I have to say, not more can be added. Thanks, Juan Fernando. Have a nice day.
Grazie.
Grazie al Dottor De Capitani. Many thanks to Dr. De Capitani. Many thanks to Professor Savino, and many thanks to all of you to be here. And it's very important for us to have this kind of debate, this kind of meeting, because is always useful, in particular, looking at the next negotiations, next trilogues that hoping soon will start about the new pact, because as you know, on the 20th of April, if I'm not wrong, in LIBE we voted the files of the new pact. And then we voted also the first reading in the plenary session. So now the European Parliament has a first reading position, and we are looking for the position of the European Council to start the negotiations. So very briefly, an introduction on myself. I'm a member of the European Parliament. In the past term, I was the European Parliament rapporteur on the Asylum Procedure Regulation. As you perfectly know, the European Commission presented in 2016 a proposal to review the directive on procedures, on the directive of 2013. And in 2020, in 2020, the European Commission presented a new pact amending also the Asylum Procedure Regulation. As the President, López Aguilar, said just a few minutes ago, it was very hard to manage a position within the European Parliament. It was very hard because we started from very different positions, because we started from a proposal presented by the European Commission that was not what we expected, generally speaking. For some things, it was what we wanted, and for many other things, it was not coherent with the difficulties that, in particular, frontline member states were managing. So it was very hard to manage a text, to get a compromise. And finally, what we get was a compromise. That means that was something that was not was not fully successful for each political group present in the European Parliament. But when the European Parliament achieves to this kind of compromise, that means that is a good text because everyone has to do a step behind to reach a common position. So about the procedure, the regulation, the Asylum Procedure Regulation, in very practical terms. The main achievement of the Parliament position were, first of all, an enhanced guarantees for asylum seekers, in particular, the free legal representation. The free legal representation ensured at all stages and degrees of the procedure. And this was very important, and there were a lot of debates about that, because for some political groups, that meant that each single member state should spend a lot of money to ensure the legal representation in all of the stages of the procedure. But we strongly believe that this constitutes an important guarantee for the effective protection of the rights of the asylum seekers, and from the other hand, it allows also a better procedure. That means a high quality of the application presented, and also in the long terms, it will reduce the number of appeals lodged. So also for member states, in very practical terms, in economical terms, it would be an advantage for each member state. The second point, very important, is a short time frame of the procedure, because we realized that the most frustrating thing for the asylum seekers and also for member states was the procedures that were very, very long, the time very, very long. So this limbo in which every asylum seeker remained for months and also years, because many times it took 18 months or even more. It was very difficult to manage for the asylum seekers and also for member states receiving migrants. So the deadline in the text that we managed in the European Parliament, the deadline for evaluating an application for international protection is 6 months in the case of ordinary procedure and 2 months in the case of accelerated procedure. About the accelerated procedure, in the proposal of the European Commission, there were a lot of cases in which the accelerated procedure had to be applied, but we prefer to limit it and to have it as a mandatory procedure, just in the case of clearly unfounded applications, fraudulent applications, and applications made for the sole purpose of extending the state on EU territory. We thought that these 3 cases were the most important, and the cases where clearly there was a criteria for the application of an accelerated procedure. Otherwise, a spread application of this kind of procedure had been detrimental for the rights of the asylum seekers. So the third point is the reduction of bureaucratic burden for member states of first entry. This is the hot potato of the entire pact on the asylum management, because the burden of the receiving migrants, of the procedures, of the examination of the application for international protection were on the hands of the first country of entry. So the Commission, in the text of in the proposal of the procedure regulation, proposed a mandatory admissibility procedure. The mandatory admissibility procedure was very, very debated, because there were some members coming from particular member states that thought that it was absolutely important to have a mandatory admissibility procedure, but finally we prefer to have it optional. To balance the needs of the member states that would apply it and the needs of the other member states, in particular frontline member states that would like to don't apply it as mandatory. It was a point very debated because I remember many colleagues said, but we are debating about a regulation. We are leaving back the directive and we need mandatory rules because otherwise we remain with the directive. So we need that all the procedures are mandatory because we need, if we now are debating about a regulation, we need the mandatory procedures for all the member states that are the same, etc. But again, we prefer to remain with an optional admissibility procedure because, again, this additional step would mean additional bureaucratic layer with finally no very practical utility. And also because this new admissibility check would be based on a highly controversial criteria, such as safe third country concepts that it's not easy to individuate the safe third countries. I mean, we also worked on a list of first country, first safe third country, the country safe country of origin, and the safe third country. 3 different kinds of safe third countries that was really until the end we said a lot of time, okay, this is the last shadow meeting, thank you very much, we managed to have a text, so next time we will vote, and then the meeting in the next meeting we started again to debate about the single term. It was really difficult, but finally we managed to have this admissibility procedure as optional. And also other 2 very practical things that we managed in the text, but that are very important when we think when this procedure will be applied by member states, are the presence of a single document for the asylum seekers. So it should not be replaced in the next steps, but it will remain always the same in the different steps of the procedure. And the only audio recording of the personal interviews, because about the terms of the procedure, a problem that also we realized that caused the very long procedures are that each single personal interviews should be registered and right in every single word said by the asylum seeker. And it takes a lot of time. It takes time also for the translation, etc. So having an audio recording is much more easier because if in the final synthesis there is something that the asylum seeker doesn't recognize as true, there is always the audio recording that can be the proof of what we really he really said. So this was very briefly the main points that we managed in the text of the European Parliament that we voted, and then in 2020 the European Commission presented an amendment to this regulation. As President López Aguilar said, we are still working because we are still waiting for the position of the European Council to start with the trilogues. And about the new amendment on the asylum procedure regulation, there is something that personally I don't like a lot. In particular, the detention, because with this amendment voted also by the European Parliament, people will most likely be held in detention, adults and also minors, because if minors are with a family and are over age 12 years old, they can be held in detention. So that's something that we don't like a lot. In the past text voted by the European Parliament, we put a ban on the detention for all the minors. Independently that they was unaccompanied or with family, that they was more or less aged of 12 years old, even because it's very difficult to understand if they are 12 years old or a little bit more or a little bit less. Is something very, very difficult. So this is a point that we don't like a lot, that I don't like a lot. And also the extension of the geographical scope, because this is another point that allows member states to keep asylum seekers subject to the asylum border procedure in places that are not in the proximity of the external borders. This was to help maybe member states that now don't have the possibility to hold asylum seekers next to borders to use other kind of structures. But I mean, frankly speaking, also in juridical terms, I find it very, very strange. Also because, for sure, Professor Vedsted-Hansen will speak about it next to me. But with the screening procedure, there is this fixio juris that is very, very strange, also in juridical terms, and it's I don't know what he think about it, but in my point of view, is something that put at risk also the rights of asylum seekers. Yes, these are the main points that leave me a little bit skeptical on this new text amended by the European Parliament on the Asylum Procedure Regulation. So I will stop here. As the President López Aguilar said, arriving at this text, this position for the European Parliament will be very hard. We managed it, but there is a lot of work to do and a lot to improve, but it's absolutely very important that the European Union gets a common position and a European management of migratory flows, because otherwise the time goes on and hello Tineke, and we remain also at the same starting point. Thank you very much for your attention.
Thank you, Laura, for your intervention, which is very timely, moreover, because tomorrow the working group in the Council will discuss their current compromise. But you already announced several observations, which will be extremely interesting to follow when you will start the trilogues on this issue. Now I will give the floor to Professor Jens Vedsted-Hansen of the Aarhus University. Thank you, Professor. The floor is yours.
Thank you very much, Chair. And thank you to the organizers, both within and outside the Parliament, for inviting me to this event. Although the title of the roundtable includes the terms strategies and challenges I'm afraid I'm not an expert in strategies, so I'll rather look at challenges. I don't know how much I can talk about challenges in implementation in the strict sense, but I will try to highlight some problem issues that will become clear only at the stage of implementation of some of the proposals which are now pending on the or in the Asylum Procedures Regulation. My comments will be mostly based on the most recent, at least as available to me, the most recent compromise text by the presidency, dated 17th of May, which I must say has been quite a surprise to me. I'm going to talk first a little bit about pre-entry screening, then about asylum border procedure, and linked to that also inadmissibility, which will be able to be decided in border procedures, and then finally just a few words about the return border procedure. First, about the pre-entry screening. I think there are essentially two approaches to the notion and to the substance of the proposal for a screening procedure regulation. One is that it's just a kind of fortified border checks. The other approach is that it will be a novel device in the asylum procedure. The first position has been emphasizing that essentially the pre-entry screening will just add to what we already know from the Schengen Borders Code and the Eurodac regulation, and just emphasize or reinforce the obligations on member states based on these instruments. Another approach, which I have launched on a couple of occasions, is that it may also create an additional barrier to access to the asylum procedure. Maybe the problem is that we don't know what's going to happen, because the proposed regulation is including or based on rather unclear notions, and certainly on lacking procedural safeguards during a screening, and not least in the subsequent debriefing. Therefore, it is simply unknown whether the pre-entry screening will be just a kind of more effective border control, or it will be resulting in de facto decisions pertaining to the asylum and return border procedure. I mean, that's how the Commission presented the proposal, that it was just a kind of assigning asylum seekers to the relevant procedure. That's true, although such decisive decisions, de facto decisions, ought to be based on more clear criteria and including also safeguards. Of course, then safeguards may be applicable at the end of the whole exercise, whether it results in a return decision or an asylum rejection, the negative decision. But the problem is that we don't know what's going to happen at the end or at the transition between screening and border procedures on asylum or return. And that's what I consider the most obvious risk, that not only will the screening become de facto decisive, but it may also, maybe in certain member states in particular, which have less good faith in implementing border exercises, it may also become de facto merged with the border procedures, and may easily result in premature return decisions that might even entail the risk of collective expulsion. So much about the screening. Then about the asylum border procedure. It should be noted that according to the proposal, and that's also in accordance with the initial 2016 and 20 Commission proposals, the asylum border procedure is supposed to be able to result in both inadmissibility decisions and negative decisions on the merits of asylum applications, if they are being examined in the accelerated procedure. Here we have to have also a look at the proposals concerning the accelerated procedure. We already had in the 2016 proposal the reintroduction of EU designation of safe countries of origin, which had also been sort of somehow proposed already in 2015 in the proposal that never really moved anywhere, with some potential candidates to being safe countries of origin that were, at least in one case, pretty problematic, to say the least. In that light, that we will now have EU designation of safe countries of origin, I have always failed to understand, and I still fail to understand, the added value of the proposed new acceleration ground, which is based on the average recognition rate of 20% or lower. Previously, it was even in the proposed crisis regulation raised to, I think it was 75%. I tried to find that percentage in the current or most recent version. It seems to have gone, but I'm not sure about that, to be honest. But in any case, it will be, it has been maintained in the proposal for the procedures regulation. And as I said, I think it is linked to elements of both arbitrariness and over bureaucratization, because if the exceptions to that recognition rate rule are going to be taken seriously, it may result in pretty complex concrete assessments anyway, which are, of course, sitting ill with the very idea of having a fast-track asylum border procedure. Well, so much about that. Then it should also be mentioned that in this context, of course, that precisely for this acceleration ground, as well as two others, the asylum border procedure will be mandatory. That has always been the idea since the 2020 proposal, and it seems to be still the case. So the combination of mandatory application of the accelerated procedure and mandatory application of this particular acceleration ground raises some concerns which could be challenged, I think, or could be the basis of challenges. And I hope some good faith people in the parliament will also convert that into strategies. I'm not the one to devise the strategies, but I hope you'll follow up on this. Then finally, on border procedures, of course, it has been often mentioned that it seems to be a potential detention framework. We don't know yet, really, because there is no clear basis for that, but I think there is a clear indication, of course, that movement will be restricted. And I think it will be understood at the member state level in the implementation as either requiring or presupposing detention. It's at least very likely, and I think also we have information that it was de facto intended by the Commission, but they didn't just didn't want to make it clear and to include a clear legal basis and specific procedural safeguards. So it will all depend on how the asylum border procedure will be combined to the detention grounds in the Reception Conditions Directive. Next, importantly, inadmissibility decisions will be able to be taken in border procedures. The inadmissibility grounds based on safe country notions, either first country of asylum or safe third country, will only be optional. That's, of course, a kind of relief for those who are a bit concerned about this. But still, it is important that the safe country criteria as regards both first country of asylum and safe third country are vague, and I think it's fair to say in brief that they are substandard as compared to international law obligations. As I said, they may be applied in border procedures, and there may certainly be a risk of these notions or criteria working or operating as irrebuttable presumptions of safety, precisely because of this border procedure context. And even combined with detention, it may have to become particularly fast-tracked, so to say. As regards to safe country notions, I think that the term effective protection as defined in the proposal, in the current proposal, Article 43A, is interesting and deeply concerning. Even in the text, it's officially termed not a concept, but a notion. I don't know whether there is any deliberate distinction between notions and concepts, but I think it may be quite somehow illustrative. And there are interesting things about it because it will be, for one thing, it will be applicable outside the scope of the Refugee Convention, but it will also become applicable even to state parties to the Refugee Convention with geographical limitation. That has to be understood as a Lex Turkey, I guess. And in any case, in addition to the lowered criteria for defining a country as a state third country, also the threshold for rejections will be significantly lowered, because the connection requirement, which is quite firm in the current directive and which was included yet modified in the 2016 proposal, is now only, according to the presidency proposal, it's only optional depending on member states' national law. As far as I can see, that will enable Denmark's Lex Wanda. That doesn't matter anyway because we're not bound by the regulation, of course, but it would just justify or enable member states to apply transfers or outsourcing to third countries to which asylum seekers have no connection whatsoever, because it's up to them whether they want to have a connection requirement. It seems also to be going to enable, say, third country practices such as those implemented by Hungary vis-à-vis, in particular, Serbia. As far as I can see, they are also failed today because they don't include a connection requirement, and of course also the safe country criteria are problematic in that regard. But that may all seem to become justifiable under the proposed criteria. So I see some quite serious challenges in both inadmissibility grounds and the asylum border procedure, and in particular in the interlinkage between the two phenomena as proposed. Finally, a few words on the return border procedure. Ever since the 2020 proposal, it has been on the table that return decisions were going to be issued as part of, or even simultaneous with, rejection of the asylum application. That is still on the table. And although that may seem to be a quite bureaucratic or even hardline position, I would say that this is in itself actually, I think, a quite useful simplification of the procedure. I don't consider that problematic per se. The problem is rather that it's not a standalone solution. It seems to be based on the idea that if only we make quick return decisions, then we can more readily or easily or effectively return people. That may well be the case. I'm not sure about that. It could be true to some extent. But I think efficient return would also be a matter beyond decision-making and also beyond the physical context, which will probably in any case be detention or de facto detention situations. Because if rejected asylum seekers are going to be kept in a waiting position, that is quite likely to become the case in the form of detention, based on probably the recast return directive, I assume. But in order to make return policies efficient, I think it will be important to incentivize rejected asylum seekers towards assisted return, which can then be termed voluntary to some extent. It is currently in the proposal that there must still be an option or a possibility, a window for voluntary departure. But I think that could be a point of developing implementation policies and strategies, because if that window of opportunities for voluntary departure should become effective or successful, I think additional efforts have to be made in terms of devising mechanisms for assisted voluntary return. I know that still we can discuss, or you may challenge the term or the concept of voluntariness here, but in any case, given that a person knows that sooner or later she or he will have to leave, then maybe assisted return programs could be helpful to that regard. Thank you so much for your attention.
Thank you to you, Professor, for a very interesting intervention. I may be wrong, but there is a lot of work for legislator, but in future also for the judges. Okay, now I think that the floor is for our good friend Tineke Strik, who will. Sorry, Daniela. I will pass.
Thank
Please,
you.
Daniela, take the floor.
Thank you very much. My name is Daniela Vitiello, University of Tuscia, and it's a great pleasure and honor to chair this panel on integrated border management and the role of EU agency in such a prestigious venue, which recalls the role of the founding fathers and in particular of Altiero Spinelli in the process of European integration. And the pleasure is first and foremost linked to the high standing of the two speakers who will discuss the state of play and the challenges related to the integration of external borders of the European Union. Professor Tineke Strik, member of the European Parliament and professor of Citizenship and Migration Law at Radboud University, and Mariana Gkliati, assistant professor of Migration and Asylum Law at Tilburg University. But before I give them the floor, I would like to outline the second reason why I am so excited to chair this panel today. And this is because the European Union integrated border management has become a sort of natural bridge between migration and asylum policies on the one end and their operational management on the other. I'm glad to the previous speakers, because they very well outlined the interlinkages and the blurring between, these two fields of competence and policies. The very same idea of merging migration and asylum management and connecting it to border management underpins the building blocks of the Asylum and Migration Management Regulation and the Asylum Procedure Regulation. At the same time, the operational involvement of EU agencies is a prerequisite for the functioning of the screening regulation and the crisis and force majeure regulation. And from my standpoint, this is part of a shift of European solidarity and responsibility from the political level to the operational one. And of course, this shift to operational solidarity may offer a viable alternative to the political impasse in migration and asylum policies by creating a sort of level playing field. This is at least been said, and reducing the political and institutional gaps between the national system while contributing to an integrated administration of the borders. Nevertheless, the role that the agencies can play at the implementing level remain, from my viewpoint, constructively ambiguous and undefined. And I think that this constructive ambiguity is not accidental. As the operational strategy for return, the operational mechanism for the external dimension of migration, the multi-annual strategic policy for the IBM, and so on and so forth, demonstrate this constructive ambiguity about the role and responsibility of EU agencies allows them to extend their tasks well beyond the formal mandate, and at the same time, it limits their ability to streamline the implementation of EU law by domestic authorities. And with this in mind, I give the floor to our first speaker, Professor Tineke Strik, and I really look forward to your reflection on these challenges and the way ahead. Thank you.
Thank you. Thanks a lot, Daniela, and also for organizing this event, the whole organizations, and for inviting me there. Sorry, I missed you, Laura, but I was really also very interested to hear your views, Jens. So if I'm allowed to, in the end, I will also say a few words on your remarks. But now, indeed, on external borders and human rights, challenges are way ahead, and it's very closely related to the screening procedure, but not only. I mean, it's a bigger issue, of course, and I would highlight it the broader context. And the agencies are in good hands of Mariana, so and she will highlight that. I think the current challenge, if you talk about challenge, of course, is the huge flaws in the fundamental rights compliance at our external borders. Almost all external border countries are violating the human rights, the right to have access to an asylum procedure, but also the right to human dignity in most of the cases. And they have become more systematic, more blatant, more open, and not only in practice, but also enshrined in national legislation. If you look at Lithuania, Poland, Estonia, and Hungary, and more maybe to follow. And this impunity, so the complete silence from the Commission, but also other member states, is actually an implicit encouragement for the border countries to continue these violations. And this has actually led to this, I think, structural non-compliance. If you have a firm reaction and sanctions, it would not have gone so far as the practices that we see now. We called upon the Commission many, many times to start infringement procedures, but also to use the funding, because in the many regulations regulating the funding of border management, there is this compliance, this obligation to comply with fundamental rights. But so far, the Commission is not willing to use those instruments. We have now the Schengen Evaluation Monitor mechanism, where fundamental rights are being inserted, incorporated, and also the obligation for involving national monitoring bodies. We have to see how it will work in the end. I mean, with the current accession or the recent accession of Croatia, and where there was no attention paid at all towards the pushbacks, it's not very promising. What the pact doesn't foresee, of course, that also newly adopted rules will be implemented and enforced. I think, I mean, as long as we don't have that guarantee, what are we talking about? New legislation. I mean, it all comes down to respect for the rules. And of course, in the screening regulation, we have this proposal for establishing a monitor mechanism. This only sees monitoring of the screening procedure. And this is why in the Parliament's position, we expanded the scope towards border surveillance. I also wanted to have encompass border checks, because I think also there a lot of things are going wrong, but still border surveillance would be an important addition. We had now a second trialogue with the Council, and the Council is completely reluctant to do so. It says, but this is national competence. Whereas this is not the case, because we have the Schengen Border Code, and we have this obligation coming from EU law to respect fundamental rights there. So this will be a huge battle to see if we will manage to stretch the scope. And what we also did is establishing more guarantees for the independence of the monitoring body, the expansion of the mandate, so really the possibility to investigate, to have access to all the information they need, all the spots, all the assets, and also have more safeguards that they are sufficiently funded. Because without all these safeguards, you know, you can end up with a sham construction. If we look now to what's happening in Greece and Croatia, this is the case. The Commission seems to be specifically for Croatia actually satisfied with how it's going, whereas we hear from the practice, from the ground, the opposite. So that's also not very encouraging. And in this way, a monitoring body could even have the opposite effect, because it undermines maybe the authority for all the other reports from UN, international organizations, NGOs, with consistent and credible information about the practices. So for the Parliament, it's a really key provision, and I really hope that we will manage to have some improvement there. If you look at the Council agreement, they did the other way around. They really weakened the whole thing that was already weak when the Commission proposed it. So what I actually see, if I look at the whole context, we see that the whole pact actually aimed to ensure more responsibility sharing and to have more solidarity among the member states. It's very clear that member states are not willing to do so. If I look also at the council compromises so far, there's indeed no mandatory relocation. We still are having the first entry criteria. So this mandatory solidarity could stay meaningless in the end. But I have the feeling that member states have another strategy to get the border countries involved, namely on the one hand, allow them and enable them to outsource their responsibility to neighboring countries. So to strengthen the external dimension in the pact. And on the other hand, to allow them to use many derogations from access to an asylum procedure, the procedural safeguards for registering the claims, etc., etc. And I think they feel they need to give something to the border countries because they don't relieve the responsibility, but they actually extend the responsibility by the obligation to register everyone and with the border procedure. So I really feel that this whole strategy comes in the end at the cost of fundamental rights and the standards for asylum seekers and also the common system, because if you have the possibility to derogate from any standards, we don't have a common system anymore. We simply have differences that will increase also the lack of trust among the member states, which is already at a low. So yeah, the whole exercise will then be deemed to fail. And this, I will touch upon both quickly because the external dimension is really strengthened more in this pact as well. You see it in the AMMR, where member states can also contribute through capacity building in third countries, by using their diplomatic channels with third country authorities. But also, of course, you see that that the EU is more and more also leaning towards funding the external cooperation. And you see already, of course, a lot of bilateral cooperation with, if I think of Hungary, Serbia, but also Spain, Morocco, but also Italy, Libya, and Italy, Tunisia. This is all leading to preventing the departure of migrants and entering into the EU. And this is really now the core business of the EU. When I visited Italy, I talked with an ambassador of another country, and he said, we always disagreed on everything if it came to internal policies, but now we have found the Holy Grail, and that's the external dimension. So this is actually, everyone agrees on making sure that people cannot enter the territory anymore. And at the moment, the Commission is preparing also a kind of multi-country migration program for the southern neighborhood, which is very much focusing on investing a lot in border control, detention, and returns. And protection is actually hardly touched upon. Yeah, so this is relieving every member state from the responsibility. This is the way out, the way that I see it. And if you look for the derogations, you will come back to that later on. But there you clearly see that for the instrumentalization regulation, this file has been stalled in the parliament because we said we first need to have a fundamental rights impact assessment on what it will mean. All those far-reaching agreements. And what we hear from several sources is that the Council really aims to merge the instrumentalization regulation with crisis. And that will indeed be the whole list of derogations. And I think this exactly is the link also with the external dimension. We push, we empower, we push the third countries, but we also empower them by making them powerful in steering us, because we make ourselves completely dependent on them, most of the times on autocratic regimes, which could indeed use this dependency by threatening with sending migrants. And if you then look at the response from the EU, it's the asylum seekers who are instrumentalized again by us, by not allowing them to benefit from the common standards that we have. So this is not the right direction, I would say. The Parliament 2 years ago in a report called for fundamental right impact assessments on cooperation with third countries. independent monitoring. All these things are not respected. And the problem for the parliament is actually that we are very much sidelined in all those policies in this externalization. So I think where the council and the commission are really linking both, we should really try to get instruments and use our incentives or leverage also to do the same. If I now want to come back a few words on screening, also what Jens said, that indeed what I see also as a problem is that this refusal of entry that is linked to the screening procedure also makes everyone eligible to be processed in this external border procedure. This is one linkage that I see. I'm not sure, at least I think that we need to be very vigilant that it will end up in being an instrument blocking the access to an asylum procedure. I was also a bit confused, to be honest, that the decision on which procedure will be followed after screening is not made in the screening procedure. It's about the form, it's about the checks, but then after that, the immigration authorities are deciding somewhere else on what's happening with them. And this makes it very blurry. And also what legal safeguards need to be in place during the screening procedure already. We found as a compromise in the Parliament's position that at least if afterwards there would be a rejection of an asylum claim in the border procedure, that this whole screening procedure and the form that is being filled in there should be able to be challenged by the lawyer saying, but look, I was not eligible for the border procedure as such at all because of, the vulnerability checks, everything that was exchanged and given as information about me. So I had to be channeled in a normal procedure so that a national judge can take that into account while judging the rejection. It's a bit poor, but this is a way, and it was a political compromise to at least have some safeguard that there will be judicial review of this whole procedure. And regarding border procedure, I fully concur with all the elements that you mentioned, Jens, of the risks. What I also found very risky and maybe with even more far-reaching consequences is that there's also a mandatory procedure foreseen for those who have been presenting false info or documents. So Article 41 under C, because that would mean that almost all asylum seekers can be channeled or have to be channeled through the border procedure. And when I visit Italy, I also saw that in the new decree, they are already anticipating on that. Everyone who doesn't have authentic documents is channeled in the border procedure. And this is large scale. So, we really have to see and hope that this will change through the negotiations. But I think this is, of course, the aim also to keep everyone there. And one thing I really find it interesting, you advocate for assisted returns also in detention in such a border procedure. In the recast return directive, we almost have a Parliament's position now. We also have that during all stages, there should be assisted return programs. So not only in the voluntary or part or whatever. So hopefully that we will manage to have more obligations on that. I will stop here. Thank you.
So thank you, Tineke, for this comprehensive and thought-provoking analysis of the challenges ahead for the external action. This idea of a full of-the-root approach engaging third countries is quite telling, of the direction. but also, for, highlighting the linkage between instrumentalization and prices and force majeure regulation and monitoring issue, which is very important also for the role of EU agencies as advisors of the guardian, the commission, which should be, in charge of monitoring at least in the last documents of the pact. And with this in mind, I move on to our second speaker, Professor Mariana Gkliati, and I would like to invite you to discuss a little bit the role of EU agencies in the implementation of the pact, as outlined in the last revised proposal. So thank you, Mariana. You have the floor.
Thank you very much. Thank you, Daniela. Thank you, Tineke. And thank you all for coming and attending online on this very urgent and important conversation. So I will speak today of the continuous move towards further centralization of asylum and border management, and of course the central role that EU agencies, EU migration agencies play there. And when I talk about EU migration agencies, I mean Frontex, the European Asylum Office, or EUAA now, and Europol. And I will speak of the increased human rights risks that this brings with it, and of course the consequent need for greater accountability. So already in the 1997, we passed from the intergovernmental model in migration and asylum policy to a more harmonized approach with the Treaty of Amsterdam. And a growing role is then given to migration agencies in implementing these policies, with Frontex, of course, in having a central role. And this role has been determined by two parallel trends. Firstly, since the abolition of the internal borders within the Schengen area, we have been witnessing a growing emphasis on the control of the external borders, which is argued to be the unavoidable price of free movement. While the establishment of safe and legal channels of entry remain limited and predominantly discretionary and ineffective, actually, in practice, the development of policies of non-entrée has been rapid. And in general, the turn in European politics towards intolerance, protectionism, and securitization has profoundly influenced the EU's agenda on migration. So basically, border control has become today's equivalent of migration management. And the second parallel trend is the widespread phenomenon of agencyfication. Agencies represent the delegation of powers at the EU level and have been replaced or have replaced the regulatory committees developed in the 60s. And today they constitute part and parcel of the EU administration, of the EU institutional structure, and their creation is considered one of the most critical institutional developments. So while the three migration agencies were established in the beginning with an assisting and coordinating mandate, due to the gradual expansion of their competences, the tasks of Frontex, the EUAA, and to a more limited extent, Europol, have become more operational in nature. And with a growing number of surveillance operations and return operations and a budget, of course, continually expanding, Frontex has become the most important actor in border management in Europe. While Europol was established in 1998 with a mandate to facilitate the exchange of information between the member state, it has now acquired widespread operational tasks in support of migrant smuggling and human trafficking investigations, including establishing and supporting joint investigation teams on the ground in the model of Frontex joint operations and joint teams. EASO, or the new EUAA, set up to provide operational support to member states in matters of reception and asylum determination, has now asylum support teams again on the ground, which can be deployed to provide emergency support to member states. And since 2015, the EU has also moved one step further, more systematically towards operational multilateral cooperation and interagency cooperation in the hotspots in Italy and in Greece. And the powers of these agencies have also been progressively expanding beyond EU borders Tineke touched upon it as well. I'll be happy to dig deeper into that in the Q&A if possible. So now with this move from the intergovernmental comitology model to the supranational model of agencies, the EU takes a considerably more direct and active role in migration management. We cannot fail to notice that. So given the inherent sensitivities that these activities entail, and I'm talking about human rights sensitivities, the EU should not only be considered as an actor in promoting and protecting human rights, but also as a potential author or violations, or potentially complicit in violations that can be attributed to member states, third states, even private companies. So once these sensitivities actually develop into violations, the question of responsibility and the accountability of the EU and its agencies becomes pertinent, pressing, actually. Especially recent controversies, of course, involving Frontex have made undeniable evident that a robust system of accountability is absolutely necessary, essential. However, the accountability avenues themselves are fragmented and ineffective, whether we're talking about an internal complaints mechanism at Frontex, a fundamental rights office, or judicial avenues before the Court of Justice that are often very limited, offer very limited access to individual applicants. The approach of greater accountability is not what we see in the new pact. So the transformation of EASO to the EUAA, which was agreed already in 2021, was a key initiative of the pact, and I will not talk about this. We have a representative of the EU Asylum Agency in the next panel. The rest of the instruments of the pact now, to get to the more current developments, fail to integrate the role of the agencies properly, and they also fail to balance the accountability needs with the agency's existing and new tasks. And I will make here two observations. Firstly, the mandate of Frontex is not formally enhanced as such, but there is certainly more Frontex. So the Commission further emphasizes in the pact that the goal of intensifying returns, which is identified as an overriding objective. And the pact puts forward a number of mechanisms, including swift return procedures. We talked about it, a system of return sponsorship, and an EU return coordinator. And Frontex has also received a central role in implementing the new return goals, with the European Commission Vice President Margarita Skinas calling it the European Union's Returns Agency. Let's see how that will play out. So, moreover, the Frontex Deputy Executive Director on Return is tasked with supporting the EU return coordinator, and Frontex will also provide additional operational support in return sponsorship. And that is quite new. So according to the Commission, this will include tasks additional to the ones carried out by Frontex by virtue of its 2019 mandate. And this operational support in return sponsorship, since it is not included in the European Border and Coast Guard regulation, will also not be covered by the accountability mechanisms that are included in the European Border and Coast Guard regulation. I'm talking about fundamental rights officer, fundamental rights monitors, individual complaints mechanism. So we're going to have two parallel systems on returns. We will have Frontex return flights monitored by fundamental rights monitors, and where individuals will be able to issue a complaint, an individual complaint, and also return flights during this bilateral cooperation framework of sponsored returns, where Frontex will be assisting in them, but these mechanisms will be completely absent. So this will definitely need to be rectified in one way or another in the proposals. Now, secondly, I talked before about the proper integration of the agency's existing tasks, and there we don't see appropriate reflection of these tasks, of the existing executive functions of the agencies and their embeddedness in the screening regulations and the border procedures, and also asylum procedures regulation and its accompanying documents include only passing references to the role of EU agencies in these procedures. And this does not reflect the reality in practice, the reality at the hotspots, and the role of the EUAA that has been essential in operationalizing the hotspot approach and processing so many asylum applications in Greece. It has become essential. So as a result, these instruments fail to regulate the joint implementation patterns. And this is important. This is a core issue. In fact, one of the main problems that impede attempts to hold agencies accountable is that they operate in a multi-actor environment, be it Frontex joint operations or the hotspots in Italy and Greece. There are multiple actors operational there, and this multiplicity of actors and the collective nature of the harmful result make it difficult to pinpoint responsibility. And this essentially functions as a wall behind which actors can hide their own responsibility, shift the blame to others, and this problem can in fact be resolved with an understanding of shared responsibility amongst the actors. Basically, since no single actor is entirely and independently responsible for the outcome, the actors should be ideally jointly responsible. And in fact, in such multi-actor situations, and I'm coming to an end so that we can have a little bit of time for the discussion, it becomes very difficult to identify all the individual responsibilities. So all different responsibilities meet and interact to produce a harmful result through this cooperation of the different actors. And only when the responsibilities meet can the harmful result occur. Therefore, the responsibility, like the outcome, should be collective. So such shared responsibility approach is still to be desired in the instruments of the pact, but also, of course, in the existing legislation, starting from the European Border and Coast Guard regulation. I will stop here. Thank you very much. I'll give the floor to you.
Thank you very much, Mariana. It's indeed very interesting what you said also about this concept of shared responsibility. Is it really fit for purpose? I mean, in the terms in which it is outlined in Frontex regulation, and what is its core content? This would be a question. But before this, let's take the questions from the audience, and indeed we have one question for Tineke from Jonathan Philip Aus, Federal Working Group on Asylum and Migration of the Green Party in Germany. And Jonathan is asking Tineke to elaborate a bit further on the reasons why the envisioned institutionalization of the legal fiction of non-entry in combination with the generalized detention of asylum seekers and the application of safe third countries concept constitute a serious violation of human rights. So this is the question for you. I guess we can add some questions from here. Yes, please.
Yes, thank you. I want to, with two MEPs present, I want to dive right into political questions. And when you've been presenting all the challenges with the APR and the alarming latest council positions, how robust is Parliament going to be in the trilogues? We see already you've had this really difficult and tense process to reach the Parliament compromises. And for us, the Parliament compromises are the absolute lowest that this should go on all the files. But of course, the nature of trialogue is further compromise. So I think a related issue to that is just to hear your thoughts on the APR. I mean, what we're seeing now is just not workable. So what does that mean for implementation? Are we going to see the implementation of regulations that are so full of exemptions and discretion? And so your thoughts would be, both of you would be very interesting. And of course, Jens as well, please.
Thank you. We can take a last question.
I have a question for both Laura and Jens concerning screening, border procedure, their inter-training, and the question of let's say, the prioritization of the examination of cases with a high probability of return. I guess this is more for Jens, but I'm really looking forward also to Laura's answer. So if we prioritize the migrants who have, the asylum seekers who have a high probability of return, this means, what about the others? I mean, the others are going to spend months in detention. Yeah, if we assume that after the time limit for detention expires, they are free to move in the Schengen area if they cannot be returned, what would be the purpose for border procedure? In the new proposal for recast return, we have an exclusion, but I would be interested in learning more about that, because here I think there is an important issue of implementation. I mean, if we detain people who do not have any realistic possibility to be returned, then the whole system becomes dysfunctional. And not only for the administrative resources that are invested, but also for, you know, human rights that are infringed upon without any purpose. So what I would be interested in hearing from you on that. Thank you.
Thank you very much. I will give now the floor for answers in reverse order. So Mariana, and then Tineke, and then we move to the first panel. So Jens and Laura, thank you.
Okay, thank you. I will only say a couple words about your question, Daniela, about the content of shared responsibility in the European Border and Coast Guard regulation, and is it fit for purpose? Well, the short answer is no, but I think you already knew that. So basically in the European Border and Coast Guard regulation, we have this Article 7, which was greatly celebrated when it was first proposed. It's on shared responsibility, but unfortunately this article doesn't tell us much about what this shared responsibility is and should be. And that is why in practice it is not very much implemented, or we don't see it working out in practice. A parallel development, that's why I'm happy with this question, because a parallel development to the pact is that the Commission is currently in the process of evaluating the European Border and Coast Guard regulation, which they're hoping to finish by the end of the year. So we will see what this will come from that. And in this, with this opportunity, we're preparing also shared guidelines on, or joint guidelines with several academics on shared responsibility and what this should mean. And there are different, several proposals in this regard on the interpretation of Article 7, for example, that it should include determining ex-ante attribution responsibility and a rebuttable presumption that the different actors involved in joint operations should be held jointly responsible unless there is reason to have exclusive responsibility, and also proposals about the non-contractual liability of the agency and Article 340 of the European Border and Coast Guard regulation that should be explicitly addressing issues of aid and assistance and de facto competences of the agency. So hopefully there is still developments to come there. What has not been of help for the interpretation of this article and in general shared responsibility is the Court of Justice of the European Union. The case law of the Court of Justice is quite weak with respect to joint liability. And there is very much room, there is a lot of room for an opening to international law standards of joint responsibility. I will stop here because I'm very interested to hear the rest of the questions.
Yeah, thanks a lot for the question. Jonathan, first, indeed, you are spot on in gathering those three situations, legal fiction of non-entry, border procedures, and the bottom-down criteria on safe third country. Indeed, this is a very dangerous cocktail, I would say. I think in practice that would indeed lead to people who have to stay at the border and are facing there with a deficient asylum procedure. If you already look now in Greece, for instance, where everyone is being rejected because they entered the country through Turkey, then you also see that, especially with those watered down criteria on the link, that could happen to more and more people, and not only in Greece, but for instance, also with Italy at the moment that there will be a deal with Tunisia, for instance, that could also be triggered by Italy. And if you then look at the border procedure, if you get an inadmissibility decision, you really actually need to have legal aid before the decision already. You need to be able to get legal advice, to know about your situation and the consequences. And that is certainly not guaranteed. And I think the more people will be processed at the border, at the external border, the more we will be faced with a lack of capacity in those border countries for sufficient legal aid organizations or lawyers, but also judges in the end, who are qualified to really also review those decisions. So I see a lot of difficulties, and the more watered down the criteria are for safe third country, the more discretion probably for the countries to interpret when a country will be safe. And in that sense, it would really be necessary, if this would be in the end in the regulation, that the Commission should come with guidelines on how to interpret this in order to, to have at least some boundaries on the discretion of the member states. So I foresee really a cumbersome asylum procedure, a lack of capacity to have sufficient support and advice. And the detention situation as such, it makes people already be faced with a very precarious situation. And it's up to them to challenge, to rebut the presumption of safety, which is already a huge task. So yeah, I think it will really affect, in the end, the right to asylum, I would say. If you don't have a proper procedure with not proper legal remedies, because this is also up to be seen when there will be suspensive effect or not in the Parliament's position. It's already very, very weak on that. So let alone what in the end the final agreement will be. So indeed, I really think the access to asylum, but also the right to an effective remedy will definitely be under threat in this situation. One thing on the legal fiction, I mean, we talked about this a lot in the Parliament and also with the legal service. What does it actually mean in practice? The legal service always tend to say nothing because all standards are applicable, but then you could think, why do we need it in the first place? So maybe Jens can say something about this because you are very an expert on refusal of and on the legal fiction of non-entry. I think it does some things, and at least it enables people to channel them in the border procedure. We now also have a huge discussion with the Council because we deleted the screening within the territory, because I think that would also mean legal fiction of non-entry for people who may be here for years already in the territory. And the Council is very, very eager to keep it, the screening within the territory. So that will open up also a whole debate and confusion about the legal fiction of non-entry in that sense. Yeah, your core question, Catherine, like how solid will we stay? I agree, the current compromise is already a very tricky one. We were not happy with the end result, as you know. And I see a huge amount of political pressure on the different political groups, at least already to say we should have a pact in the end, and the more this has been repeated and repeated, the less possibility and space there is to really look at the content, to reflect, is this making things better in practice or not? Because if not, we should simply, do away with it and start implementing the current rules. I really feel that in many political groups, they have gone beyond that moment. And they simply want to have a pact. They want to get rid of those negotiations for years, but also to show something to the electorate, like we did something towards the current migration crisis or whatever. Yeah, and that makes you less critical. And of course, there's a lot of ties between political groups and those who are in the governments of the member states. Not so long ago, I heard also from Germany saying, look, we're currently actually alone with Portugal and Luxembourg because all of the governments are very much into keeping asylum seekers outside of the EU with all those, consequences of lacking safeguards. So this combination makes me very pessimistic of where we will end up in the end. I think these were my questions.
Thank you. I can't say much about the fiction of non-entry. I always understood it as being sort of somehow combined to the strategy of introducing detention without specifying it and without appropriate safeguards. As regards Mario's question on the provision, I assume you refer to Article 41A concerning the option to prioritize examination of those for which there is a high probability of return. It's an interesting reversal of the 2020 proposal in which there was a permissible exemption from mandatory border procedures in cases where the state of or the country of origin was uncooperative in the sense of the visa code. That seems to have gone, and now it's the other way around, that if there is a cooperative state somewhere, and I mean, the wording of this proposal is not very clear, but I take it to understand that it could be either country of origin or a safe third country or first country of asylum. It's not entirely clear, but I think that's how it should be understood. So that would mean then that we could have sort of accelerated fast-track procedures in cases where we have an often neighboring country to which we can return them applicants on an inadmissibility decision based on the safe third country notion. That's what I assume it will be working like. And that somehow confirms or even reinforces my assumption that there is a risk that admissibility procedures will be really fast-tracked to the extent that, in particular, if they are somehow combined or linked or merged with screening, the screening phase, to an extent where it will be de facto impossible to rebut the presumption of safety. The rebuttal threshold is already being weakened or reversed also in the proposal. So I think that the time factor is also important here. It may simply sort of speed up to an extent that rebuttal will be de facto impossible or meaningless. And of course, I mean, already under the current directive, member states are free to prioritize as they want. It's not an exhaustive indication in Article 31 as it stands. So this is sort of incentivizing member states to do even more to get rid of applicants at the admissibility stage, which can then be very close to the screening procedure, I assume. Sorry, by the way, I forgot to answer your reference to detention versus free movement. I don't think that asylum applicants, once detention is no longer possible, they don't have a right of free movement in the whole Schengen area. I mean, we all know the scary monster of secondary movements. But of course, that could then sort of also be combined with the risk or chances, as you did, depending how you see it, of reintroducing internal border checks, which is, at least in my country, often being justified by reference to secondary movements.
And if I may add, the revision of the Schengen Border Code, of course, also foresees in the possibility to immediately return third country national to the country, member states where they came from. It is said it's without prejudice to, the asylum acquis and Dublin. But in practice, I guess it will be a huge hurdle for people to move on. Yeah, exactly. Yeah, that's a better formulation.
But it's also what already happened in the past, in the recent past, that a lot of member states introduced the internal border controls given to national security and so on. But finally, it was just to block the secondary movements and push back migrants. So very briefly, because I don't want to repeat what colleagues said before me, I completely share what Tineke, Professor Gkliati, and Professor Vedsted-Hansen already said. What I can just add is answering to the question of Mr. Savino is that the European Commission already said that we will need 450 billion of euros for the period 2021-2027 to implement just the screening procedure. Only for this procedure, we will need 450 million euros. That means that all of this amount is needed to create new infrastructures, implement the staff, update the border cross points, and that gives an idea of the important work that each single member state should do to implement this additional step that would be introduced if the new pact will be approved. But to go to the question of Dr. Woollard, it will approved or not, I'm pessimistic as Tineke, because we already saw how difficult was in the past term get a common position in the European Parliament, and finally all the work was blocked in the European Council. Now we are going in a different way, as was already said, because a lot of member states are approaching on the external procedures, the externalization of the management of migratory flows, and this is a main point that is in common between a lot of member states. So the paradox is that the right-wing political groups and the right-wing governments said we don't need a European approach. We can continue going with our national laws, etc. The left-wing political groups and governments push to have a European approach, but if we continue going in this way, in the actual line of the European approach, we have the risk to have a bad management of migratory flows, in particular for the protection of rights, values, and etc. So I don't know what to expect and what to wish, because I think that we absolutely need a European management of migratory flows, but with this situation, with this text, also when we get the proposal in 2020 from the European Commission, it was clear that the European Commission went lower than before, just to go in the direction of the European Commission, the European Council, exactly the member states, and get something. Now we will start maybe trilogues with the Spanish semester of the European Council, but Pedro Sanchez presented the resignation, and Spain will go to vote in July. So it will be hard, and we will see, hoping the best. Thank you very much.
So thank you all. And we're now going to have a 10 minutes break. We're going to resume at 10:15. 11:15, sorry. And thank you for being here in 10 minutes. Thanks.
Please take your seats. We will start in 1 minute. Ciao, Francesco. Glad to see you.
To see you too. Do you hear me well?
Perfectly. Thank you so much.
I'm sorry I can't be there in person. It would be much better, but it's still a great honor and pleasure to be with you virtually.
Our pleasure, but we miss you. Okay. Yeah, but I think everybody's sitting. Yes, we can start. Okay, now it's time to move to the second session, which is devoted to asylum management. There are two panels here, one on reshaping solidarity or reiterating Dublin with a question mark, and the other on crisis management, lessons from the present. I will moderate the first panel, which starts with this question, reshaping solidarity or reiterating Dublin. Let me just briefly try to clarify the meaning of this title. We all recognize that solidarity in the management of migration and especially of asylum seekers is weak at the European Union level. There is no working mechanism of responsibility sharing for receiving asylum seekers and process their asylum requests. There have been ad hoc solutions such as the temporary relocation scheme in 2015. The lack of solidarity, though, is evident, and this is probably one of the very reasons why there is a clear trend towards externalization. Let's keep them away, otherwise we cannot manage them in a solidaristic way, and the frontline member states will be overburdened. Now, we know that there has been and still is an attempt to reshape and indeed create solidarity in the proposals of the pact, but we know that the approach to solidarity is becoming thinner and thinner. It is now clear, for instance, that in the RAM proposal, relocation will not be compulsory. The Swedish proposal, compromise proposal, emphasizes the voluntary nature of this tool. Therefore, countries that had always been opposed to the compulsory relocation, such as Hungary and Poland, no longer oppose the core of the proposal. There is still a trace of compulsory relocation in the crisis regulation. We will see what happens on that file. In addition to that, it seems that the original ambition to expand the Dublin criteria for determining the responsibility of a member state for an asylum application are again becoming, it's not going probably to reach the initial ambition. This criteria initially provided for the extension to family members and siblings. Now it seems that according to the last compromise text of the Council, this expansion is not anymore on the floor. And one may wonder whether this isn't, after all, an incentive to secondary movement. If I have siblings somewhere else, why shouldn't I try to reach them? So the question is, doesn't it all amount to Dublin Reloaded? Okay, now in order to answer these questions, I give the floor first of all to Alison Gatt from the European Union Asylum Agency. Many thanks for having accepted our invitation, Alison. Her topic is how important is to prevent secondary movements to restore mutual trust. Alison, you have the 10 minutes that we mentioned at the beginning for your presentation. Thank you.
Thank you very much. And yes, I'll try to be shorter. I know we're always chasing time. Thank you very much for having me. I will try to answer your question. First, I'll just mention briefly the current situation. That's a little bit the context. Then I will get into the topic of secondary movements and Dublin and the link with mutual trust. I'll touch on some other elements that I think are important when it comes to mutual trust. And finally, I'll also touch a bit on the agency's work that is linked with mutual trust, perhaps at a more technical level. At the end of the day, the agency is not a political player, so to say. We're not directly involved in the legislation. So just a word about the current situation. I think here I have to mention that we have seen a significant rise in asylum applications again. We will have our annual asylum report will be launched in the beginning of July, and that will provide a bit of a recap, but we've already made a lot of data available which already shows this. And of course, that is alongside the 4 million or so Ukrainians that are benefiting from temporary protection in the EU. So altogether, there is a situation of pressure within the Union, a situation of pressure that member states are facing. I'll just speak louder. And this, of course, is having an impact, which brings me to secondary movements, which, of course, do play an important role in this context as well, to the extent that it is, at the end of the day, the failure to respect what the Dublin regulation says. No? It's a movement away from Dublin. And we've seen different causes of that, which I won't get into right now because they are complex. But of course, this element of pressure that member states are facing and the resulting difficulty in complying with the EU acquis is one of the causes. Of course, we have these court judgments that also prevent transferring people back to the member state responsible. But of course, Dublin was conceived as a system for making sure that in the area without internal border controls, we always have one member state that is responsible for an asylum application, as we always do have a member state that is responsible for an application. So secondary movements, of course, mean that this system is not efficient. It's not being applied. It results in prolonged procedures, multiple applications in different member states, legal uncertainty, and increased bloating of caseloads. And of course, in the end, as was mentioned earlier, the internal border controls, which don't help anyone. Some argue that secondary movements result in increased pressure for some, so an imbalanced distribution of responsibility, but of course others will say that it is Dublin itself which creates this imbalanced distribution of responsibility, this unfair balance of responsibility. But at the end of the day, Dublin is itself based on mutual trust, so the very notion of Dublin presupposes that all the member states are applying. Okay. So the very notion of Dublin presupposes that member states are applying the same level of the same procedures, the same standards, and the same level of conditions. So it is of itself based on mutual trust. On the other hand, Dublin itself is also a basis of mutual trust. So turn that over. We have seen that as soon as Dublin is not functioning efficiently, we immediately have this concern that we've lost mutual trust. Member states have lost mutual trust in each other. And then to come to the next point, and my question then is it really just a matter of preventing secondary movements to restore mutual trust, as you've put it here? And here I want to again mention Ukraine and temporary protection, because I think for the first time we saw a situation where people in need of protection were allowed to move around within the EU. We didn't talk about secondary movements because we didn't have Dublin applying. And they were able to move around and obtain temporary protection in the member state where they wanted to have that protection. So again, we mentioned before, asylum seekers and beneficiaries of protection don't get free movement in the EU, but this was one case where we had an element of this free movement. And we saw that they were able to have their rights immediately in the member state they chose, and therefore swifter integration. And, you know, in a way, this benefited both sides. So it's not just beneficiaries of temporary protection, but also the member states. And we carried out a survey. We have this survey that is ongoing. But amongst the questions there was why specific member states were chosen. So why people chose to go to one member state as opposed to another. And the top reasons here were work opportunities, there were family links, they were not the level of social benefits that they would get, as we often, you know, associate with secondary movements when we talk about secondary movements and Dublin. So really one might have thought that this could inspire the next discussions on the pact, but maybe that's a little bit too progressive, maybe one day in the future. So of course we see that the Asylum and Migration Management regulation, the proposal still keeps the criteria for allocating responsibility. And to the extent that that is part of the legislation, then yes, I think preventing secondary movements will remain important, because I think also, as Ms. Strik mentioned earlier, at the end of the day, I think what is more important for a mutual trust is having legislation which works, which is respected, and which is applied. So if these criteria for responsibility are part of the legislation, then yes, preventing secondary movements will remain important. And we see, I think, different ways of achieving that in the text from the Parliament, in the text from the Council. Whether you look at screening, border procedures, all of these elements, I think, also have this element of contributing to preventing secondary movements. But then on the other hand, I don't think that preventing secondary movements on its own will be enough for restoring mutual trust. And then we come to the title of the panel, and yes, we have the solidarity element alongside the Dublin element. And again, mutual trust, at the end of the day, we're talking about all the member states. So not just the member states that face the consequences of secondary movements, but also the member states at the border, the ones that will say that the Dublin criteria results in unfair pressure on them. So that is why I think solidarity is an equally important element. And again, to come back to what was mentioned earlier, the balance between solidarity and responsibility, this has been sort of the mantra from the very beginning of the negotiations. There are two sides of the same coin. And I think it will really be important to strike the right balance between solidarity and responsibility if we really want to restore mutual trust. We see that at the end of the day, the discussions on the pact all seem to revolve around this, perhaps as the core of the discussions also within the council now. They were also, I think, very important within the parliament, because it is that balance that needs to be struck, to have an agreement on the pact, but also to have then mutual trust, have that pact being respected and applied. And then I will make one more point, which is to say that I also don't think it's just about the legislation and respecting the legislation, but also about the practice and the technical level. I do think there's a lot to be said for the bottom-up approach as well. And here, I think the work of the agency comes in as well. You're probably aware that the role of the agency is to support member states to implement the common European asylum system. If the pact gets adopted, it will be to help member states to implement that new architecture, new acquis. We provide training for the member states' authorities. We develop guidance and recommendations and standards to member states. And we also support them on the ground with our operational support, as was also mentioned before. And I think all of that also contributes to developing mutual trust among member states. We have all sorts of thematic networks which bring together member state experts around the table, discussing their common challenges, their different challenges, trying to find solutions. And I think that is equally important. To give you a very practical example, we do have the network for the Dublin network, of course. And you're probably aware of this roadmap that was agreed between member states for improving the implementation of Dublin. So now I'm talking about current acquis. And the agency is providing a lot of support in that context, at a very practical level. So, for instance, one of the steps was to develop these information sheets about the member states' procedures and standards and their situation. Those are now gradually being uploaded onto our website as well. This was something that was important to member states, also in the context of Dublin, to be able to use that also in courts and so on. So there's also a lot, I think, to be said when it comes to practical implementation and practical cooperation. But of course, the legislation will always remain the most important structure, because it's within that structure that we then have to work. So I think to conclude, I will say that I think preventing secondary movements is important to the extent that it's part of the law. So I think what's most important is to have legislation which is respected and which is applied well. That is the way to have mutual trust. And to get there, we need to have this balance between solidarity and responsibility. So both preventing secondary movements, because that will be part of the acquis, but also solidarity. And we'll continue following the negotiations to see where this balance lands. Thank you.
Many thanks to Alison, Gatt, who rightly questioned the connection between secondary movements and mutual trust by making reference to the management of the Ukrainian crisis, which, for instance, showed us what happened with free movement. It's an important lesson that we will address in the next panel. Of course, mutual trust depends also and perhaps mainly on a working legislation, which is sufficiently effective to make things predictable. And but on the other hand, it's an old lesson of history that migrants vote by feet, right? So, with this in mind, I will turn to Francesco Maiani, a dear colleague from the University of Lausanne, who will deal with the issue of relocation and take-back procedure and the implementation challenge. Francesco, 10 minutes also for you. Thank you.
Sure. My timer just started, and I know that it's 47. You will cut me, so I will try to be very short. Well, thank you. Thank you very much, Mario, for inviting me. It's always a pleasure, and I'm sorry, as I said, not to be there with you. But it's already excellent that I could be present, at least virtually, for this seminar. Indeed, you started from the point that is near and dear to my heart, which is the practicality and the implementability of all the solutions that are being devised right now in this discussion. And I would start from reminding us all of the double meaning of pragmatism in this discussion. There is pragmatism in the negotiating room, which is trying to make enough concessions to all the key actors that they can finally agree to the proposal and get it through. And that's indeed a precious form of pragmatism without which the European Union would not have advanced. But then there is also pragmatism on the ground, the fact of devising formulas that are capable of working on the ground. And if I look at the 2020 proposal, which is still the basis of our discussion today, I would say that possibly it might have the former pragmatism. There is something in it for everybody, but I'm not that convinced that it has the latter, the pragmatism on the ground and the ability to work correctly on the ground if we look at the experience. Now, let me recall where we come from here. We all know where we come from, but still it's useful to remind a few important facts. We have had 28 years of a Dublin system that has consistently underperformed. I mean, there is still this perception that the Dublin system stopped working during the crisis that affected the European Union. It's not true. If you look at the figures, it's a remarkably, admirably consistent underperformance. The Dublin system has for 28 years delayed by months and sometimes years the examination of applications, which is entirely against the original goal, which was to have a swift way of starting the examination procedure. It has given rise to hundreds of thousands of complex administrative procedures, very often ending in litigation, for an average rate of transfer of 1 in 4, meaning that you have all this massive work and then basically what you manage to get is that about 1 transfer out of 4 agreed transfers is implemented. And in the process, the natural distribution of applications, meaning what had happened when you let people, apply somewhere by chance or by will, well, that distribution has been changed by infinitesimals over the years. So all of this Sisyphus work for an absolutely marginal impact of the criteria over how the applications are distributed. And if I may reply to a question that was put before, no, Dublin does not create the imbalance because Dublin does not move enough people to do that. Dublin preserves the imbalances. That's a different thing. Third effect we have seen, routinely giving rise to serious interferences in human rights and placing national officials to whom I've spoken in extremely uncomfortable positions of resorting routinely to coercion and pushing not a few applicants to prefer clandestinity over being in the system. And finally, and not least, fostering mistrust and animosity between the member states. You just have to consult the various letters that have been produced by various subgroups of the member state over the past years, and eroding any trust that might have existed between the applicants and the national authorities. So the track record of the Dublin system is really quite impressive. And the reasons for this are all known, and they are all fully recognized in the 2022 roadmap to improve the implementation of Dublin. 1, in here, it's grouped into 5 in the roadmap. I group into 3 because I like the time. 1, the inherent complexity and the limited resources to run those procedures. 2, the lack of engagement with the applicants, which we usually simplify into saying that they abscond, as if they were, acting on irrational impulses. But we perfectly know that they have very strong reasons to evade the system. And the experience should teach us that whether we want it or not, they are important actors in the process. Without them, the process cannot work properly. 3, the zero-sum game that exists among the member states. If every applicant shipped from one member state to another means one cost avoided and one cost incurred, you cannot expect member state to behave cooperatively on that. That's simple, and 28 years of experience bear this out, okay? And some of what I said also applies to the relocation in 2015, 2017, which were our only life-size attempt to do mandatory relocation union-wide so far. And what we know is that it moved about 35,000 persons over 2 years and counting, out of about 100,000 planned. And it showed both the great value of the exercise for those who managed to benefit from it and its great limitations. The capacity of that mechanism is probably in the some thousands per year, okay? Maybe tens of thousands, but it will not be the solution when we have applicants hitting our shores. Mario, is my connection okay?
There is a connection issue.
You well?
We hear you, but okay, now it's reestablished. No, we now see you.
If it starts again. Okay, I'll try to I'll change connection.
Okay.
Is it better?
Yes. Yes, we can hear you.
Okay. That's the essential. Seeing me is not so important. In case I will stop the video because it takes bandwidth.
We also see you. We also see you. Go on, please.
That's super. Okay. So the relocations, I talked about it. So what we have in the RAM proposal of 2020 is a bigger and better Dublin system with more threats to people in order for them not to move, more coercion, perhaps just a timid olive branch in the form of extended to siblings. Then you have this idea that you make the system faster by cutting down on procedural time without always thinking it through, though, because, I mean, for instance, there is this draconian restriction of the right to appeal, which is just bound to create more litigation at the ECHR level. So it will eventually cost us more time and not less. And there is this idea of, in the name of stopping secondary movements, making responsibility harder for the first state of application, which is aggravating the imbalance inherent in the Dublin system, on the promise of a solidarity mechanism that is frankly quite unworkable because it's just bewilderingly complex. It just foresees a daisy chaining of procedure and transfers as if, you know, transferring somebody was something easy and cheap and fast. Now, from that basis, we are having negotiations that are pulling into two completely different directions. If you look at the EP report, you have an attempt to take the proposal and cut back on some of its excesses. There is more real link criteria, trying to engage the applicants a bit more, simplifying the bureaucratic elements, etc., of the relocation, etc., etc. If you look at how things are evolving in councils, we are in the idea of no siblings, no more compulsory relocation, basically keep it as it is with some, you know, limited tweaks. So we are now reduced to discussing whether we should have siblings or no siblings in the family definition, and whether we need to have compulsory relocation or no compulsory relocation. And frankly, I am not really sure that we are having the right discussion. That's the point. We are not having the right discussion if we want to have a system that works on the ground. The real question that should inspire our work is, how do we produce a system of responsibility sharing that is swift and cost effective? That is number one. That's not, if you look at the proposal, it's a mammoth proposal having 100,000 variables and sub-procedures and coordinators, etc. My impression is that we're going in the wrong direction. The key question is, how do we make a system that is capable of putting these people into asylum procedure as fast as possible? Offsets are a good idea in that context, but they're about the only one. The second question is, in order to do that, I know that my time has run out, so I'll go quickly. I'm close to my conclusion. How do we engage the applicants, and how do we avoid having to ship them around coercively? And here we must just stop with symbolic amendments. Like, I find very well-meaning amendments in the EP position saying we give them the right to ask for the application of the discretionary clauses. But we know perfectly well that it will be a simple matter of routinely saying no. That's not going to change the dynamics at play. Just as, you know, saying that there is a commitment to all the extent possible to take into account the wishes of the applicants in the context of relocation is not going to change the dynamics at work. We need to have a paradigm shift here. And I'm wondering, and here I'm pushing it towards the next panel, isn't Ukraine a massively interesting example? We have about 7 million persons who arrived in a short time and that have been housed around Europe without any of the drama that surrounded the arrival of 1 million Syrians back in 2015. I know situations are different, and I know that the situation of Ukrainians is not perfect by any means now. But do we really say that this experience doesn't count for anything when we are discussing the new mechanism of responsibility sharing? I'll stop here and let the rest of what I wanted to say be taken up during the discussion and question and answer. Thank you.
Thank you so much, Francesco. I'm very sympathetic with your view. I now open the floor to the discussion. We have a question from Marcello Di Filippo, who is connected online, and I'm not sure whether it is for Alison or for Francesco, but the question is, how come that in the current and planned asylum legislation, very little is said about composition and qualification of refugee status determination authorities? In practice, this leaves such a wide room to member states with no mandatory indication on independence, status, permanent training, etc., to hinder the application of international and EU rules on asylum in a consistent and HR-based way. This is the question, and then there is another question from Paola Regina. I leave her the floor. Please use the microphone.
I want to ask, first question is on the procedure. And I just want to be, it's a question on the ground. In Italy, in Spain, and in Greece, we have a high number of refusal of the asylum request, very high number, like more than 70%. And on the other side, we have a high number of approvals of judiciary procedure, very high. And the judicial procedure are like five or more, 5 or 6 or 7 years long. So we have, it is very expensive for the member states, very, very expensive. We have the witnesses of the presidents of the court in Italy, in Spain, in Greece. We have a lot of official data on it. So the question is, can the European Union, and in the new proposal, promote a monitoring on it, because it is very expensive for member states, this high number of administrative refusal in the first instance. The second question is on the independence of the administrative monitoring procedure on the borders. And the question is very brief, this one. How the monitoring procedure can be independent when it is connected with the interior minister of each member state, and it is dependent on the interior minister. So I have this doubt. And the third one is on the illegal pushback, because we have a connection between the pushbacks and the bilateral agreements between states, like Italy and Libya, or the agreements with Turkey. And the question is, how this, if it is possible, European monitoring on these bilateral agreements by the European Union, of course, on the conformity of human rights, of European rights, because we have a lot of, in Italy, but also in the other states, a lot of judgments on it, where the judge has provided that there are a lot of points of this bilateral agreement that are very, very full of doubts on the conformity on European law. Thank you. Thank you so much.
Thank you, Paola. Marcello Di Filippo is pointing out that his question was about the previous panel. I apologize for it. But of course, if the speakers want to address his question, they're very welcome. There is another question from Daniela.
Not working, this one, I don't know. Yeah, okay. Thank you to Francesco and Alison. I would like to ask Alison, what do you think the role of the asylum agency can be in the proposed reform? And to Francesco, I would like to ask you to address the issue of take-back requests, which is replaced in the reform by a system of mere notification, further limiting the possibility of the member states to object the transfer, and whether you think this change can help balance a little bit the additional burden on frontline member states, which derives from, you know, the screening regulation, the Eurodac regulation, and the recast reception condition directive. Thank you.
Okay, I will abuse my position as moderator. I will add another question, which is relocation on one end, take back procedures on the other. The first one, relocation, didn't work properly in the temporary scheme. Only 1/3 were relocated, even less. Take-back procedures don't work properly. Francesco told us 20% effective, 25% effective. I saw some figures that suggested even a lower level of effectiveness. So my question is, if this is Dublin reloaded, doesn't it all amount to a series of failure which somehow protect the possibility, the de facto possibility of migrants to move around and cross borders, with the only new addition that there will be the possibility of pushbacks at the border, given the proposals of revision of the Schengen Border Code? Thank you so much. So I would reverse the order, and I will ask Francesco to address some of the questions that he wants to answer, and then we move.
Yeah,
return to
I will perhaps start from the last two, which were more directly addressing the topic of my speech, but then I would like also to come back to what Dr. Regina and Marcello pointed out, because there is a very strong connection between what I said and the quality of asylum procedures throughout the Union. But first of all, to Daniela, frankly, I regard that, I know that it's still being discussed, right? And you got the European Parliament saying, we don't want to change that to a mere notification. We still want to have a fully fledged procedure for takebacks. And then you got the other side, which seems to be oriented, the council that seems to be more oriented towards retaining the notifications. I don't regard that, frankly, as being an extremely important point here. And I will explain myself. The time you gain by skipping the requests and reply is trivial when you compare it to the time you lose in the Dublin procedure in general, and to the time created by litigation, etc. I have direct knowledge of some procedures that lasted well into the years before we could be rid of the question of which was the member state responsible, and even if you don't go to this pathological extreme, you still are dealing with months. How much time do you gain by asking member states not to reply, to take back requests, etc.? Doesn't seem to me to be so decisive. On the other hand, it is not the aspect that I regard as being the most problematic from the standpoint of what we usually call border state, but in reality is the first application states. Because I would like to point out one thing. It's not that the Dublin system disadvantages the border states. The Dublin system disadvantages whatever states happens to be the first where the application is made, because that's usually where it will end being examined, even though I know that there is Article 13 and all the rest. The state that is most seriously affected by the Dublin system is the one that has to first do the initial screening check, do the Dublin procedure, and do the first request. And since the transfers are so low, the rate, then it means that you generally stay with that burden. Now, in that context, to me, the thing that is the most detrimental to those states is the fact of shortening the deadline of the take charge request and coupling that to the obligation of making a full safe third country screening before that. That will mean that you got plenty of applications that will end up being in the responsibility of that state just because of the passage of time. The abolition of take-back requests and notification, to me, is a way of showing that we are trying to cut down on time, while in reality multiplying the possibility of incidents. Because if you look at the paper on the Dublin roadmap, one thing that is clear is that there is very bad coordination between the member states when you have to effect a transfer, even when there has been acceptance. Now, do it with just a simple notification, and you are sure to have double the cases of bad coordination on that. So that would be my take on this point. I don't know if I really replied to Daniela. Mario, I try to be brief because I don't want to monopolize the time. We are not solving the de facto free movement of applicants, but the problem to me is that this de facto free movement is a de facto free movement that is made in unnecessary suffering, because the people who are de facto free moving are either disappearing into clandestinity and alimenting and nourishing an industry of inter-EU smuggling, and they are giving up sometimes their own claims to protection and their own claims to reception. And so this is lose-lose for everybody, because member states don't have control. Movements tend to be unauthorized, and you are creating a whole market of clandestinity while people are being pushed into situations that are very uncomfortable and socially explosive. So the whole game would be how do we make it so that people do not have all these incentives to move irregularly, to go underground. And one of the possibilities would be to stop with the illusion that we can set predefined criteria and tell people go there or go there without their will being involved, and to start instead having criteria that they could ride with voluntarily. Then you have uncostly transfer and you have no secondary movements, and you can't organize those to just examine their application where it is lodged. That's it. Take-back transfers, you can't eliminate that completely from the system, because otherwise you end up in a system where you cannot allocate responsibility. That's a completely different thing, right? But at least for the initial allocation, you could go for something much simpler. And this leads me to make one consideration on the other questions that have been made. One big absent element in the whole discussion that we are having about solidarity and responsibility sharing is that we still don't have a level playing field. Now, a fully level playing field is, as the French say, une vue de l'esprit. I do not believe 1 minute that we will be able to create a European Union where the social services are the same from Tallinn to Porto and from Dublin to Thessaloniki, okay? That's not going to happen. But what we can have is a European Union where reception conditions are decent across the board, and where it's not a lottery if you go here or you are examined there, and where maybe once you are recognized as a refugee, you can go where you have the best chances of being embedded in your social network. That would take away a lot of the incentives for secondary movements, but we are not discussing this. Instead, we are discussing hyper-bureaucratic systems to determine quotas and move people around, where we have a huge problem of disparity of conditions between the member states. That's why I'm saying we are not asking ourselves the right questions. And the question of that Paola Regina, I mean, she was raising it in a context that is different from mine, and I don't have much to say about that. But of course, there is a matter of reducing the aggregate burden before we start discussing about how we share it. How about not having hundreds of thousands of take charge procedures that end up nowhere before we discuss the rest?
Thank you very much, Francesco. Now I turn to Alison.
Thank you. Yeah, I would just like to say something brief on the first questions that were made before I address the specific issue on the role of the EUAA. So the question relating to the qualification and composition of asylum authorities, and I understand this was addressed more to the previous panel, but I just want to mention here that the proposals do require that the asylum authorities, those engaged in determining asylum applications, undertake at least the core training provided by the agency. We do have a very broad asylum curriculum, several modules from beginner to more advanced to the more complex issues. And we do have a lot of participation by the officials from the member states. So we do see a lot of engagement there. Of course, it is not an obligation that every single person will have undertaken all the training that we offer, of course. That's a different matter. But I just wanted to mention that. On recognition rates and refusals and acceptances, here as well, the agency does provide support to member states in the form of country of origin information and country guidance. So the country of origin information is the more factual information. The country guidance is also then how you interpret that information for the purposes of determining an asylum application. Again, it's not obligatory. So it's not obligatory for member states to decide a specific case in a specific way. But it is there to help achieve some convergence in recognition rates and in the decision on similar cases, let's say. And also we do see that country guidance being referred to more and more frequently in the second instances in the court judgments. Then to come to the question on the role of the agency in the new pact, I think here I'll come back to what I mentioned earlier, the fact that the role of the agency is to support member states in implementing the common European asylum system. So, to the extent that the pact would be the new common European asylum system, I think that the agency's role is, of course, going to be to support member states to implement all of that legislation. It will be a challenge, I think, for the agency as well, because we will also need to update all of our tools and so on. And we will need to see how it will work in practice, because again, I mentioned earlier the three pillars of our support. So the training, the operational support, and the guidance and recommendations and the tools and so on. When it comes to operational support, at the moment, we are providing operational support in 13 member states. So that's half of the EU member states. That's partly due, of course, to the pressure that member states are facing now. Some of those are being supported, for example, with the implementation of temporary protection, which is it's a specific development. So going forward with the pact, we will see. But basically, we can even operationally support member states with all of the procedures on the ground. Not so much the screening, because that is more the border aspect. So maybe a few elements of it, but not mainly. But with all the rest, with the asylum procedures, whether that's the border or accelerated procedures or the normal procedures, with what was Dublin, so it's still easier to refer to it as Dublin, but the Dublin part of AMR, let's say. But really with all the rest as well. Reception, we also support member states with reception. And it's from the operations to all the other tools that we provide. So, and of course relocation, because as far as relocation will remain part of the solidarity mechanism, we also support with the implementation of relocation. So the registration, the matching of applicants with the member states and so on. Thank you.
Thank you very much, Alison. Now it's time to move to the last panel. And Francesco Gatt is is going to moderate it. Thank you.
Yes. Thank you, Mario. Yes, indeed. It's now time for panel 4. We are approaching the end of today's roundtable, but we have to talk about an important topic, which is crisis management lessons from the present. So we will be addressing here mainly the issue of, well, Ukraine and the temporary protection regime that has been activated. So the idea here with our two speakers is to try to reflect on this experience and see what we have learned or we can learn from the management of the Ukrainian exodus, the Ukrainian displacement. We are maybe somehow at a crossroads because already more than 1 year has passed since March 2022. This is when the Temporary Protection Directive was activated for the first time in the history, although this instrument goes back to 2001. But on 4 March 2022, the Temporary Protection Directive was triggered. So 1 year and 3 months almost have passed, and so we have a time frame that allows us to draw some reflections. And so here we will look a little bit at the past, maybe the lessons that we have learned, and at the future, what we can still learn. Our first speaker is Esther Pozo from the European Commission DG Home. She's Deputy Director General in charge of Horizontal Affairs and Migration. And she will talk about Ukraine displacement and temporary protection, the main lessons. So here it will be a look at the past somehow, the lessons learned. And then we have Catherine Woollard, Director of ECRE, European Council of Refugees and Exiles. And she will talk about crisis management beyond the temporary protection and the future of the common European asylum system. So a look at the future here in this case. You have 10 minutes, and I give the floor to Esther. Welcome.
Thank you very much for the invitation and a small clarification. I'm the head of unity of the Asylum unit. So just to be clear where you're talking to, so you know. And but thank you very much for this opportunity and for this exchange. And I'm very sorry that I couldn't be here for the entire meeting. And I'm still trying to disconnect from my previous meeting, which was with the ambassadors on COREPER on the Pact, on AMMI and API. So.
Let us know.
And what I would say is that I think we have a shot at having a general approach in next week, but anything can happen. This is the only thing I would say at this stage. At least I see that there is a commitment to try to get a general approach in June. But now to the present, a bit to Ukraine and what is meant for the Union and the lessons we have learned. The first lesson I think that we have learned is that you should never put on the shelf a regulation or a directive, because probably you will have to use it. So the Commission had proposed to derogate the Temporary Protection Directive, and just 2 years after, or 1.5 years after, we decided that it was time to derogate and replace it with something new. We had to activate it. So maybe don't think that the crisis that you can imagine will not happen, because they will certainly happen. And this is, I think, the first lesson that we have learned, that the crisis, we tend to regulate on the basis of the past experience, but it would be better to regulate on the future experience and the ones that we cannot imagine right now, and create instruments that are flexible enough that they can adapt to all different circumstances and the needs. So this, I would say, is from the regulatory perspective, a first lesson that I think we can learn from the experience. A more political one is that when there was a moment, I think that the member states and civil society, they stood to the test. There was a situation in which we were receiving 300,000 people a day, and the member states were able to agree within 2 days that what it was needed. So it shows that when we are confronted with a crisis and we stick together, we are able to have solutions, and solutions that work for the member states and work for the persons concerned. Now, in terms of the practicalities of the Temporary Protection Directive and the protection to Ukraine, I would say that in terms of the lessons learned is the importance of civil society involvement. It would have been impossible to absorb and rapidly all the millions that came into the European Union if it had not been for citizens that very generously opened their homes to host people. And this shows that the European society can be generous when they want and when they find the right approach. So chapeau, I think, for all European citizens is the first thing we have to say, that we have a very vivid and committed society. Also that the rapid absorption was also possible because member states decided to derogate not to apply Article 11 of the Temporary Protection Directive, which is the one that allowed member states to apply some kind of Dublin type procedure. So the idea of the Temporary Protection Directive is not so different from others in which you have to stay in the country of first entry, and then if you move forward, it can be sent back to the country of first entry. And in this case, given the amount of people coming, it was really inconceivable that everybody will have to be returned to Poland, for example. If the 4 million that we have now in the territory will have to be returned to Poland and to a lesser extent to Slovakia, Bulgaria, Romania, then we will have a problem. But the ministers saw this and they decided not to basically waive the application of Article 11. What I can tell you now is that there's a certain fatigue on this. And I don't know if we were to go back to this, if there will be such a rapid activation or waiving of this provision. A third element I would say is the importance of coordination. And here I will say that we created this idea of the solidarity platform is something that we have tested in the past with the relocation mechanism, but it was more on the countries that were receiving the support. Back in 2016, 2017, we used to have coordinating meetings in Greece and in Italy, but this time it remained very local. So when there was a problem, it was a very targeted operational problem and it didn't solve the political issues. So the response that we had for Ukraine was basically to say, let's create a common solidarity platform, chaired and coordinated by the Commission, with all the member states around the table at the adequate level of representation, and also all the EU agencies. And then we also have IOM and UNHCR invited, and we have specific sessions in which NGOs also can participate. So it became really a common implementation challenge. So it was not the challenge for Poland or the challenge for the Czech Republic or the challenge for Germany, but it became like a common challenge, how we can facilitate the onward movement of people, how we can communicate to people where there are places available, how can we communicate to people their rights and what are the benefits that they get from this. So it became really this, if I say, a common implementation strategy in very operational terms. And here I would say as well that obviously the support from EU agencies was very important, and from the support from the other member states trying to help and find solutions. The other element I would say is that, of course, this was a directive that was made when we didn't have all the all the information we have now, all the databases we have now. It was very rudimentary in terms of registering people in national systems. So obviously we didn't have a way of sharing information. And that's when, from the operational perspective, it was very important to have the temporary protection platform developed in a record time of 6 weeks. If you think that EULISA is going to take almost 2 years to update Eurodac for the new regulation, and that it took the Commission 6 weeks to put in place a temporary protection platform, it can give you a bit of the idea of how fast we were, because there was a need, a real need, to say where people were, and this is also important in terms of protection of children, and also to avoid abuses, because people could move, could choose the member state in which they wanted to benefit from the rights, but we had to avoid that somebody will try to abuse the system and get social benefits from 2 countries at the same time. So this was also the element of that it was important. Not to say that there were no issues, because of course, as you know as well, under the Temporary Protection Council implementing decision and the directive, a member state can be more generous in terms that they can extend the scope of those that benefit from temporary protection. And that happened in practice quite often. So that created some imbalances that some people thought that, oh, if I am benefiting from temporary protection in Belgium, I can move to the Netherlands and benefit from the same. But sometimes Belgium was more generous in terms of the scope. So we had to inform people that not because you were benefiting from temporary protection in Belgium, for example, if you were in Belgium before the 24th of February 2022, that you would necessarily go to Netherlands to obtain the same benefits. So we also had to do a lot of pedagogy. What I think it was very important is the effort in terms of communicating with the communities, with the diaspora, and the role of the diaspora as well in informing people, in integrating people, in helping people. Particularly at the beginning, when some member states were not even yet in terms of putting in place the social benefits that they were going to give to beneficiaries of temporary protection. Because some member states apply the same regime as for beneficiaries of international protection, other member states apply the same regimes as to asylum applicants, and all the member states apply the specific regime. So, and at the beginning, some member states, we didn't even have the subsidies that they were going to give to people. So the diaspora played a very important role. So sharing of information with the temporary protection platform and the need to coordinate and have reliable data, it's important. Now, just to conclude, because I think it's important to have a discussion, what I would say is, as a result of all this positive experience, and I can tell you it was very positive. I mean, there was no member state that I know that said this was not a good idea. No member state. Because all of a sudden, we were giving them a system in which they didn't have to do almost nothing in terms of bureaucracy. The only thing they had to do is to check whether the person fell under the scope of the temporary protection. They didn't have to apply for anything because this was something that given directly by the council implementing decision. Is this your status? So the only thing that the member state had to do is to verify indeed that this person fell within the scope. And it was a rapid process that also allowed member states to spread the burden with the regional and local authorities. For example, in Belgium, it was the communes. In other places, they decided to keep it with the asylum authorities, but it allowed the system to really function in accordance with the systems in place already in each member state, with almost no bureaucratic burden. And this was very important for the member states. And I think it's one of the lessons when we talk about a crisis, how important it is to cut red tape, because otherwise it will be adding to the burden. So it was a win-win. The beneficiaries of temporary protection found themselves in a situation in which they have immediate access to rights with very little administrative procedures. Okay, in some countries it was more than others. They also had access to the labor market from the beginning, and the member states found themselves in a situation where they have to do little in terms of bureaucracy, but they had to do a lot in terms of integration. But of course, here again, the role of the civil society and the diaspora, it was crucial. A final thought from me. What is very important from the 2011 directive is how flexible it is. It is flexible. I always say that it's a directive of the old times, when there were really directives in which we were focusing what are the rights, what are the safeguards, what are the obligations. And on the basis of that, each member state can achieve its objectives and can adapt its system on the basis of that. And that proved very useful for a crisis. And this is a bit maybe something that we have to reflect upon when we are going to negotiate the crisis. As you know, the Commission considered that based on this experience, there was no need to derogate the Temporary Protection Directive. But at the same time, we also considered that crisis come in all shapes and forms. So it was not enough just to have the Temporary Protection Directive. We also needed to have a crisis regulation that will work in complement with the Temporary Protection Directive. So just a reflection that when we work on this crisis regulation, I think it's also important to draw some of these lessons in terms of flexibility, that creating something that will be able to adapt to all sorts of crises. Some of them, like this one, is millions of women and children. Others might be different. This one, we didn't have people were largely documented and they were visa-free. Others might be different. So we just have to have the right tools to be able to respond to the needs of the member states and of the people concerned and able to adapt to the unthinkable. Thank you very much.
Thank you. Thank you very much for this excellent presentation. You gave us an idea of what lessons we can learn. We have learned, I've noted down just a few keywords: flexibility, solidarity, coordination, importance of monitoring through data statistics, the importance of civil society and diaspora. So just a few important keywords that can be useful for us from learning from this experience. Now we move to the future, so to say. We have a look at the future with Catherine Woollard. The floor is yours. Thank you.
Thank you very much. So I'm going to cover 3 points. I'm going to pull out lessons from Ukraine displacement crisis from our perspective as the first point. Second point, to apply those to the current state of the debate on the crisis regulation. And then third point, conclude with a few scenarios and speculation about what might happen with the crisis regulation. In terms of lessons from Ukraine, I think above all, this demonstrated that the EU can manage a major displacement crisis when the decision is taken to manage. What is required for that to happen is really the heart of the lessons. First lesson, in a sense, access to protection immediately is extremely important, or at least access to protection or protection status as soon as possible, to avoid asylum systems becoming overwhelmed and people getting stuck there. Second lesson, I think, demonstrates that there is a major problem with containment in the countries of entry. And here we had the opposite. If there is a model based on containing people at the point of entry, those countries cannot cope, and their usual decision is to resort to pushbacks. And that's, of course, the lesson from the situation in Greece after the EU-Turkey deal, when that came in as the approach to the 2015 crisis and then the 2016 deal. In the case of Ukraine, because of the waiver or the waiving of Article 11, there was freedom of movement allowed for the people arriving. That is the ideal solution. Otherwise, relocation is a way to move people when they're not granted freedom of movement, or at least suspension of Dublin, which was de facto the situation and sometimes de jure the situation in 2015 in the earlier phase of managing the arrivals from Syria. And third point, immediate access to socioeconomic rights for people with protection status, which allows for that principle of inclusion from day one to start, and also means that people are not dependent on benefits. And then the fourth point we would note is to have this positive response is the need for an assertive and political European Commission. And we've said it before that the role that the Commission played in response to this crisis was exemplary. It was also a Commission that was focused on protection, not on prevention of entry. And if we think about the question of the role of civil society, that approach taken by the Commission also facilitated cooperation, because civil society was on the same page as the Commission in response to this crisis. And that doesn't always happen when the objective is other. Moving to my second point, if we take these 4 lessons, and there are many more, but those are 4 we would identify, and look at how they can be applied in the debate and negotiations on the current as they are on the crisis regulation. And as a whole, we would say the pact itself as a model goes in the opposite direction of the Ukraine response for reasons that have been discussed this morning. But is it possible for the crisis regulation to provide extra tools and actually help manage crises in a protection-friendly, fundamental rights-based way? And I think that remains the question. We have the European Parliament position. On the Council side, my comments will be rather speculative, because this is an early stage, relatively early stages of discussion on the Council compared to other files that may be agreed or be subject to a general approach next week. Taking those lessons, access to protection status rapidly. above all, not repealing the TPD is extremely important, and that's been decided across the board, and I think the only thing that is common to member states and the European Parliament. The Parliament has added other tools, adapting the immediate protection status proposed by the Commission and putting forward prima facie recognition. This could add back value, it could be a useful tool, and not least because it would be activated by the Commission. So that's helping meet that lesson. The border focus, or avoiding containment at the borders. If the TPD is used, freedom of movement would still be possible. Here we see in the Parliament position that lesson has been taken on board. Relocation would be, or elements of relocation would be part of the, would be mandatory under the solidarity mechanism. And the Parliament has also deleted the amendment that expands the use of the border procedure in crisis situations, which allowed it to be used for those with 75% protection rates. So that is useful. On the other hand, we don't know where Council will come, and it's likely to be the opposite direction, focusing more on containment. Inclusion, that lesson, it's too early to say. And then finally, the lesson of needing a strong Commission. I think a lot will depend on whether after the pact is agreed, if it's agreed, we finally see a switch to compliance and implementation. There's extremely complex, difficult regulatory framework that will be coming in based on regulations, but regulations that are nonetheless full of discretion and exemptions. It's not obvious how to monitor that. And the final point I would make in terms of the direction of crisis regulation, what we know of what's happening on the Council side is that the crisis regulation is being seen as the vehicle for derogations. And there appear to be discussions on 3 derogatory regimes for situations of crisis, for situations of force majeure, and for situations of instrumentalization. And that is something that we find highly concerning because it is a move away from harmonization if member states can essentially at will choose to derogate from the law at a time when compliance is limited. So final points from me, my conclusions, scenarios, all of this. Will we see a crisis regulation that takes on board the lessons of the Ukraine crisis? I think the first point is, will it be adopted in this round? There are discussions that the crisis regulation could run on into the next mandates. I think this is quite an alarming thought because if that continues, the content is not going to get better. And there is a general fatigue, obviously, on all sides with negotiating reforms. In terms of content, although from ECRE's perspective, we urge the European Parliament to stand strong on the compromises it's reached, and the Parliament's position on the crisis regulation is generally good, we fear it won't be robust. And the content of the compromises under discussion on the Council side are really quite alarming. We've gone into a situation where the deal seems to be based on border procedures in exchange for allowing derogation, with a lower focus on solidarity. Solidarity has been agreed without mandatory relocation. What the border countries want is this wide-ranging derogations, and that will come in through the crisis regulation. So if that's what's agreed, there are a number of risks. And what could be the scenario here? I mean, I have to say, from our perspective, the APR may well be unworkable, and that will lead to a situation where there will still be secondary movement, there will still be expanded smuggling opportunities, pushbacks at the border due to the increased responsibility of the countries at the borders. But member states may choose to use the crisis regulation, and many may be in what is effectively permanent states of crisis, choosing to try to apply one of these potentially 3 derogatory regimes. Now, if those regimes do not include the expanded use of the border procedure, and if an agreement is reached on the Council side where there's limited, if any, border procedure in a crisis situation, there's a question that possibly this could be better from a protection perspective than the normal regime where the standard rules apply. But that's very much a question. But I would throw that out there, given the concerns about the complexity and multiple fundamental rights issues arising with the border procedure and the APR. So as just a small side note, on Ukraine, we talk about this positive response. I think there's also a very strong need to make sure that it doesn't become a major political crisis and continue to use the appropriate tools. We put forward a recommendation to extend the Temporary Protection Directive coverage until the end of the allowed period in 2025, and to allow already discussion taking place about what will be the options post that 3-year period. Thank you.
Thank you very much for this very interesting presentation. We definitely have learned that there is potential behind the experience of Ukraine, but there are also some risks to take into account for the future. So we have now around 10 minutes for question and answers, for debate. So I would open the floor for questions, if there are any.
Hello, and thank you very much for a very interesting presentation. My question is really a follow-up on how we concluded this topic, is what happens next, specifically with Ukraine, because I think that if we want to realize which are the lessons that we take from this experience, it depends a lot on what happens, on how we end this experience. So of course we know that we have time until March 2025 to figure out what happens next. And I think that it's really not too early to try to voice out what is the best outcome after this. We have this prima facie recognition that was proposed by the Parliament that could be a good tool to support the end of temporary protection, or there are many other options, and another extension, or allowing long-term resident status to apply even to people with this resident permit. So my question is really, which are your takes on which is the best outcome to ensure that this crisis management remains a concrete and efficient crisis management? Thank you.
Thank you. I would maybe collect one more answer. I see Professor Maiani has something to ask.
Thank you so much. I just wanted to make the bridge between our two panels and ask in particular Mrs. Pozo, but this could also be extended to Mrs. Woollard. We have heard about the importance of civil society, the positive role of the diaspora, and how it helped to cut red tape. And I quote, in the case of the Ukrainian crisis, why could we not harness that positive element also outside of a crisis situation in order to allocate protection seekers and to house them in a way that has the least, let's say, footprint for public treasuries? Thank you.
Thank you, Professor Maiani. And finally, one more question for Professor Strik.
Yeah, hopefully a few, if I may. Thanks a lot, Esther and Catherine, for your excellent presentations. Yeah, I was thinking, indeed, it's really high time to think what after 3 years. And of course, the Commission has proposed in the MMR that beneficiaries of international protection should have access to the long-term residence permit after 3 years. Is this something that you also envisage that could be a good solution? And is this already a topic in the platform? And how are you, if you support that idea, what are the strategies of the Commission to get member states prepared to do that? And how to avoid, in the meantime, a race to the bottom? You already mentioned that you see people going from one member state to another with a more generous policy. I know from the Netherlands that the third country nationals with a temporary residence right in Ukraine will lose their protection of the Temporary Protection Directive as of the 4th of September. how does the Commission deal with these developments? I think it's really key that there's no regression taking place in the meantime. I would also think there are legal arguments against that if once you decided to extend the scope, that you cannot unilaterally decide to redo that. So I was wondering, how are you doing that? Also maybe in terms of enforcing compliance, if there's a legal obstacle for that. And about the platform, indeed, I think it's a very useful instrument. We always miss that. Are you envisaging as a Commission to continue the use of that platform after the adoption of the pact? Because, and what more in general is your strategy of the Commission? Now, everyone says after adoption, we really need to have solid implementation and enforcement. What is the strategy on that for the Commission? And also about this red tape, I found that a very important lesson. And the more bureaucracy, the more red tape, the more difficult the good implementation. But I think, you know, undoing red tape really requires mutual trust among the member states and common standards. And what I see with the crisis, we're going actually, like Catherine also rightly said, the other way around. So I really wonder, I mean, the crisis regulation proposal was already presented before the Russian invasion. We always talk about lessons learned, but I did not see a move in the meantime from the Commission or elsewhere, you know, what it would effectively require in terms of revising the crisis regulation proposal. And I wonder, I mean, the Czech presidency said we first need to evaluate before we, but I didn't see anything. I just see that we're still negotiating on the proposal of 2020. So what exactly, how could we more concretely insert the lessons learned into the current legislation on the table? And maybe one of the things could also be, if Catherine also rightly warns for a lot of discretion and derogations, what could the role of the Commission be, or should the role of the Commission be also in the regulations to avoid this from happening, to really make sure there are clear criteria and enforcement to make sure that all those derogations are not being abused? Thanks.
Thank you. And then finally, we are running out of time, so just one final question, please, from the audience.
Yes, I will be very quickly. The first question is, do you think that it will be possible to propose to extend the temporary protection to other groups of refugees? First question. Second, I want to answer very briefly to Professor Maiani. I totally agree with you. I'm just a witness. I have not presented myself. I'm a lawyer. And I can say, as an international lawyer and the human rights defender, that from the point of view of the protection of rights, we have a real evaluation of the rights only in the judicial procedure. And you can verify it just looking at the data, because we have a lot, really a lot, like 19% of winning procedures. So just this. Thank you. Thank you.
Okay, thank you. Who wants to take the floor first?
Shall I come in? Because I'm sure people want to hear everything from Esther, so I'll come in briefly and then let her answer. I'm just taking a few of the questions in terms of what happens after the TPD for the Ukraine crisis. We're arguing for as many options as possible to be available, and a lot of that is going to have to start working at national level as well as at EU level. So the people will continue to have the right to apply for asylum, but already, as is already the case, that is one of the worst options because of the strong risk of asylum systems becoming overwhelmed and it not being obvious even now, but certainly in a few years' time, what would be the fate of asylum claims made. The amendments to the Long-Term Residence Directive are extremely useful. That provides some options. Already we're seeing in some member states that people are moving to work-based residence statuses. This is also something important. For the Ukrainians themselves, of course, assisted return is extremely important. And currently it's the preference for the Ukrainians displaced, although that may also change as people become more included. So if there are ways to extend after the 3 years some form of temporary protection status through an amendment to the TPD or other options or temporary protection under national law, that is also a possible practical approach, because after all, 5 years is relatively temporary. So, and it should all work on the basis of the informed consent of the people concerned. And I think anything that suggests there will be forcible returns at any point is going to create, of course, insecurity, but also a panic and asylum applications. So there's a lot at stake there. In terms of extracting lessons from Ukraine, unfortunately, what we see is that there are determined effort by some governments, some political actors, to say that what has happened in response to Ukraine displacement is different. It's something completely different. This model can't be applied elsewhere. And so that kind of exists in a parallel space. We would argue very strongly that the lessons there can be applied to other crises and should be. So that may involve, for instance, activating the TPD for other situations of crisis, but it may also involve adapting the content of the regulations under discussion to take into place those lessons that we've heard that I won't repeat. And then finally, in terms of part of this, the community response, I think private hosting as an alternative to state centres has proved very successful. There are issues, there are questions, it has to be managed carefully, but I think this is also something important. And indeed, the value of allowing freedom of movement to the member states, I think, it is quite stark. It means that people have gone where they've got families, where they have prospects for inclusion, where there is a possibility of private or community hosting. So we should bring as much of that as possible into practice. And use tools such as the Solidarity Platform, which I think demonstrates the lesson that member states can work together in practical and operational matters, which is also a lesson from the EUAA's work, that when they sit down and discuss working level matters, things work. At political level, there is zero mutual trust. And I think trying to base proposals on generating mutual trust is a road to nowhere, because it is at such a low point. And to hear the way member states talk about each other, and I don't think that is going to change. I think the objective now should be to come out of all of this with something that is workable and does not too egregiously damage fundamental rights.
So thank you very much for the questions. On the exit strategy, and then I can link also to some of the other points that also are raised by Mrs. Strik. Yes, we are discussing. So the idea is to, a bit like Catherine said, we will have to see. We have not started the discussion with member states on the basis of some kind of paper that the Commission have prepared with options. We're not there yet. We're just having a bit to listen to the member states at what their concerns are. And these concerns have to be taken into account when we come up with any strategy whatsoever. And it's not only the member states concerned, we also have to look into the Ukrainian government concerned, which is very concerned about brain drain and the need for the people to go back to Ukraine and reconstruct the country. I mean, if all the clever people stay here working with the best salaries, it's not going to be also helpful for Ukraine. And of course, for the member states, what is very important is that all of a sudden these 4 million people go and ask for asylum, because then we have not solved the first problem, which is kick the can along the road, and then we will have to do it again. So these are the concerns we have received. Obviously, there is also the uncertainty for the people, something very basic, to get a rental, a contract here in Belgium, so that the apartment where I live is going to be renewed for another year, for 2 years. So all these concerns we have to take into account. And as been mentioned here, of course, there are elements that are now under negotiation that might help in creating these possible exit strategies. I think what is important is that probably there is a menu of different options, because it depends very much on the situation of the person concerned. Many would want to go back, and we have to facilitate that return with an information, but also operational and financial support. Many will want to stay. As Catherine said, they are already transitioning into legal migration type of permits, residence permits. Some of them students that will stay here until the end of the school, just to finish their studies. And indeed, the long-term residence directive, it's also the negotiations now. They are opening some possibilities that would help transition, particularly because if it's prolonged for another year, we're in 2025, so there is enough time to finalize the negotiations on the long-term residence directive, on the crisis regulation, and also I would say in the asylum procedures regulation would also include an important element is that you can waive the interview to give status. And we should not, sometimes people don't mention this one, but I just wanted to mention that the asylum procedures regulation allows the member state, when it's a clear case in which you are going to grant beneficiary status or you're going refugee status or subsidiary protection with the same rights as a refugee, to waive the interview. And that would also be a bit relieved. But of course, the challenge is to ensure that people don't lose rights. And this is how to do that is what is going to be a bit more complex. So we are in the process, we have to do it. And hopefully after the summer, we will start getting a bit more these reflections with the member states. And so all these elements we are under discussion right now. We have to be a bit careful about the lessons learned from TPD extrapolating into everything, because it's not been perfect. If you look at the concentration of temporary protection beneficiaries, at the end, you have 5 countries that have the 80%. And if you look at Poland, you look at Germany, you look at the Czech Republic, they are not in an easy situation either. So it's not that, I know that for many of you, there's the panacea of free choice, but the panacea of free choice sometimes has a pervasive effect. And because we think about, the families, the diaspora, the cultural links will solve the problem, but it might lead to a concentration of people in a few member states, and then they might have an issue, we might create a political issue in those countries. So, but what I think is important, and this is something that the Pact will also take into account, is, for example, access to the labour market. It's going to be reduced in the compromise that has been reached between the European Parliament and the Council. So it can be faster access to the labour market, which I think is one of the key issues to ensure that the people don't need to stay in reception centres or get subsidies. So these elements, I think they're very good. And also when we do relocation, I just remind that EUA has a wonderful matching tool. And these elements are also included in the negotiations of the Asylum Migration Management Regulation. So it's not relocation anywhere, but you have to take into account the family and the cultural links, so precisely to ensure that there is a higher degree of integration. And I will remind everybody about the Commission proposal to include siblings in the definition of family members and diplomas, with the idea as well that actually we are creating a system that is fairer in terms of responsibility rules for the frontline member states, but also for the people. So there will be also, if you look at from the member state of this, from the perspective of the destination countries, there will also be fewer secondary movements, because you are actually making the member state responsible. That is the one where people would probably want to go. On these changes on the national legislation that are happening right now, yes, we are looking into those. We are in the dialogue with member states as part of the Solidarity Platform and also bilateral to try to understand. What is important, and it is also something that Catherine has mentioned, is that these people anyway has to have access to asylum, because not the fact that you have given temporary protection doesn't mean that all of a sudden you don't have the right to apply for asylum and eventually get refugee status or subsidiary protection status. On the use of the platform, indeed, the Commission wants to continue, and I'm very glad to see that both in the Parliament's compromise text and in the Council compromise text as it stands, and I don't think that will change, there is this idea of the solidarity platform. It's not called solidarity platform, it has a different name, technical level forum or whatever you want to call it, depending on the text. So it's there because I think everybody understood that it has a big added value. Implementation is a big question. And what I think is the positive aspect is that between the entry into force of these regulations and the entry into application of these regulations, there is going to be a bit of time. Now it could be 1 year, 2 years, who knows, depending on what the compromise between the two institutions will be. And those 2 years are great because it gives us a time to implement together. So the same way we did with Ukraine, that it was all of a sudden we have to implement it together, we will have the possibility to do it in a way ex ante, in the sense that we can prepare for these 2 years to see what are the needs of the member states, what funds are available. It will fall very well because we will have the midterm review of the AMIF and the BMVI. There is also the thematic facilities. So there is a possibility there. There is a space that will also help to build trust in the sense of ensuring that everybody has the right standards, that everybody is doing what they're supposed to do. So hopefully this implementation, these 2 years that we will have there, will help us bring everybody to the same level, or at least to an equivalent level. And so on the crisis regulation, and more concretely on the discussion of the Commission, here I have to say that I think both in the text of the Parliament and the discussions that I hear in the Council, nobody wants any member state to take a decision by themselves. And I've been joking a bit in the councillors' meeting that if we continue like this, we will need a complete new DG just to implement and monitor this regulation, with the amount of times that the Commission will have to authorize something or assess something or prepare a report or prepare an implementation, whatever. But we will do it. I mean, whatever it takes for this to be agreed among the member states and the Parliament, and then to make it work. So I think, also addressing some of Catherine's concerns, I don't think you should be concerned. I think there's going to be an overload of Commission authorization decisions, monitoring, to make sure that everybody is in place. And maybe in terms of the lessons learned of the Ukraine crisis, well, I think in the terms of the Parliament, you have created this prima facie, which I think is a response to a way to the Ukraine crisis, and also, for example, the suspension of Dublin transfers. So there are elements that have been built there. I think the Council is also considering some of these lessons learned. We already saw, for example, in the Czech paper that was endorsed back in December, that the member states supported the derogation from the application of the mandatory border procedure in a situation of crisis. So these elements will come, and I will also want to say that there is a clear commitment from the Swedish presidency and the Spanish presidency to have a general approach, the sooner the better, to start negotiating for the Parliament. So the risk that this will slip to the next term, I think it will not happen. I see already that there are 2 JJ councillors meetings that are going to take place. So it shows the commitment of the presidency to move this forward. And then on the last point, can it be extended to other people? Not now. I don't think now. I don't see any member states saying we should apply this to other people. And one final thing that I think is important, because this is used also in the extent of the temporary protection. Could we amend the temporary protection directive so instead of 3 years, it's 4 years or 5 years? We have to be careful, because it sounds good to solve this problem. But again, don't look at the challenge we have now. Look at the future. And if you extend temporary protection for 5 years, you might have member states less inclined to activate it again in the future, because it will think, 3 years I can stand, but 5 years, then they will get long-term resident status. They might be eligible for nationality, blah, blah, blah. So just because it sounds attractive, but again, there's this tendency to focus on the challenge we have right now, but we have to look a bit more into the future. Thank you very much.
Thank you. Thank you very much for these exhaustive answers. One final word from Professor Maiani.
Thank you very much for the privilege of giving me the floor again. I know we are running late and I'll be extremely short. I've been listening with great attention to all that has been said, and I must point out one thing, that is that even though I tend to deliver speeches that are, very critical or hopefully thought-provoking. That's the idea. I always am aware of the great difficulty that there is in navigating these debates, and I am certainly aware of the difficult task that the Commission has in front of itself. I wanted to just return on one point that Mrs. Vera Pozo pointed out, which was, let's be cautious in drawing lessons because not everything is perfect and it's not a panacea, free choice. I would just offer two final thoughts on this. The first one is, yes, it is true, the distribution is very unbalanced, but let's look at the distribution of applicants over the past 20 years with Dublin in force. Was that a balanced distribution, or were the essential of the applicants always concentrated in 4, 5, perhaps 6 member states? So if that's the problem, Dublin is not the answer. That's my first observation. The second one is that between free choice and having this policy where the wishes, aspiration, and social contacts of applicants don't matter at all, there is a very wide gulf. And what I see is that we are doing two opposite things at the same time. We are saying for temporary protection, we leave free choice, and for the ordinary times, we are in the no choice policy. And yes, I am aware of the siblings and the diplomas, but then if you look at it in terms of what it would practically entail, I'm not so sure it will be so revolutionary. Maybe there could be a rethink about how to better develop two things, which are engaging the applicant in the process. What can he bring in, even though if he or she doesn't have a full free choice? And secondly, yes, how do we develop the real links, and how do we eliminate the criteria that do not correspond to any real link? But these were just two glosses on what was said, and I agree with the gist of it. And I thank you again for the privilege of letting me take the floor again.
Thank you. Thank you very much, Professor Maiani. Well, now we close with a few concluding remarks.
Thank you very much, Francesco. I will just, try to streamline a little bit the reading keys which emerged from this roundtable along the lines of the idea of heading towards a sustainable system of responsibility and solidarity. Are we heading towards a sort of sustainable and practical system balancing responsibility and solidarity or not? Several speakers have observed today that the amended regulations still don't set a sort of common level playing field on asylum and migration management, and also that the capacity challenge for the implementation of border procedures remains largely unaddressed, unanswered, and this is the first point. The second point is that it is not clear the extent to which the flexible solidarity and extended discretion of the member states may balance the additional burden on some member states, especially the frontline member states, which derives from the reform, so the combined reading of the different regulations. And third point, last point, the legal condition of asylum seekers, which seems further diminished by the proposed amendments, and this may create some stumbling blocks in the negotiation between the co-legislators, namely in the field of detention of minors, and border procedures and application of the legal fiction of non-entry on the territory of the member states, and linkage between instrumentalization and crisis and force majeure. So on top of that, there is the temporary protection standing there and reminding us that there might be alternatives to the containment paradigm, but still those alternatives are there just if they are exceptional. And with this, I leave the floor to Mariana for the follow-up of this roundtable and further information. Thank you.
Thank you, Daniela. I would like to thank everyone for coming, and those of you attending online, still staying with us even though we're 15 minutes late, but we're here for the closing. First of all, I would like to thank those people that helped in the organization of this event. And of course, first of all, Mario Savino and Daniela Vitiello from Tucci University and the IntoMe Jean Monnet Center of Excellence. And the team, of course, Francesco Gatt, Giulia Del Turco, and Cristina Milano. And also Tineke and Ricky van Oors from Radboud University. We have talked a lot today, and Daniela very skillfully pointed out the main points of discussion. We will not finish here. We intend to follow up, first of all, with a press release that will be disseminated today so that we can take the discussion outside this room. But also, most importantly, with a policy brief addressed to the Spanish presidency in a few days. So we will keep you all posted about that. So thank you very much, everyone. And I'm giving the floor to Professor Savino for a final word. Thank you.
We're all tired. Just a final word to express my warmest thanks to all the speakers and moderators. They've enormously enriched our understanding of the issues on the floor. To all the participants, both in presence and online, we had an average of 90 participants during the whole morning. And to Laura Ferrara, she intervened and she left, but she helped us enormously to organize this event. And of course, to Mariana for her invaluable cooperation in this adventure. Daniela and all the rest of the group are also included in this warmest thanks. Thank you all very much.